Government, sir. Government.
The conviction is altered from section 304 part 1 IPC to be a conviction under section 304 part 2 IPC. The sentence is reduced from 10 years to 5 years, and the appellants will have to pay a fine of rupees 10,000 each in default to suffer for the rigorous imprisonment for 6 months. You're for the appellant?
Yes.
You're returning your bunch of judgments. Yes. Mr. Parashar, you were there in the matter? In the matter, you were there?
No, at the time of hearing, I am not there.
Okay, because the name is different, that's why I asked. Okay. Yes.
May I please the lordship, my lord, I beg to mention item number 34, my lord. My lord, in this matter, probably the matter has become infructuous, but we could not contact the client, my lord. So it may be adjourned, my lord.
Okay. On the prayer made by Mr. D.P. Boral and counsel for the applicant, matter stands adjourned to enable him to obtain instructions. List after answering due vacations.
Obliged, my lord.
Yes.
May it please the lordship. My lord, in respect of item number 48, lordship, the state of Assam, lordship, we have filed an objection, lordship. That is not in the record, lordship. That may be followed.
May it please your lordship. I beg to mention item number 14, lordship. I was to withdraw the petition, lordship. There is some mistakes in pleadings. So grant liberty to file a petition.
Okay. Upon instructions, Ms.
And they.
And they and counsel for the petitioner seeks to withdraw this petition and to close the court again. For higher education, who is there? Mr. Kumar. Mr. Gogoi. Mr. Gogoi. Mr. K. Gogoi, standing counsel for the higher education department. And for finance, will be there. Mr. Salia. Mr. A. Salia and counsel for the finance department is present. As well as Mr. G. Bakolial and government advocate is present. Matter is dismissed on withdrawal with liberty as paid for. Yes.
I beg to mention item number 7, my lord. A typographical error in the part of the synopsis. I may be allowed to correct.
May it please your lordship. Lordship, I beg to listing of a matter, urgent matter. And lordship, what has happened? An advertisement had come out with regarding to lecturer in the dental department. The petitioner herein has just crossed the age of 38 years, 7 days. And as per OM dated 1980-992, he preferred a representation before the authority. But authority has not decided the representation yet. And the interview is on 4th, my lord. Can it be on 3rd, my lord? Much obliged, my lord.
My lord, this matter relates to compassionate appointment. The process is initiated to appoint the person, my lord. I seek to withdraw this petition, my lord, at 2 kindly.
Obliged.
With consent of other side, I beg to mention item number 9. Chief counsel for petition is out of Guwahati for some emergencies.
Okay. But it goes after view.
Sure,
Okay. List after the petition as paid for by land counsel for the petition. Okay.
May I please, my lord? My lord, I beg to mention item number 3, my lord.
Okay, on the pyramid, well, and constable the petition, arrest adjourned today. This start commencing your vacation. Yes. Let that affidavit come. Some affidavit
There are
has been
two
filed.
affidavits, my lord, I'm not finding that because morning, my lord, there was mismatch of paging number in my file, so I checked up, my lord. So I found that first of all, my lord, there is, my numbers are not telling in one of the affidavits or two of the affidavits. And then, my lord, the objection filed by, my lord, the informant and the PP is not on record, my lord. So therefore, I informed them, my lord, that I have not found those records, neither in the slip, my lord. So I advise them to get it. I'm ready for the argument, my lord. Lordship will take the argument, let that come, my lord.
My lord, so far our objection is concerned, is not in the record, of course, but we have got extra copy for lordships.
Yes, that can be taken, my lord. Let me start the argument. Only thing, my lord, on the last occasion, lordship will remember, my lord, I have sought time to, lordship has said you place the list of dates index, my lord. I prepared that, my lord, and it's coming, my lord. I'll give it little bit of time, my lord. I'll place it, my lord, end of the argument, my lord. That is on the way, my lord. Because by the time I settled it, it was morning. Now, my lord, this very interesting part, my lord. Now but so far, my lord, investigation part is concerned, my lord, because they have alleged, even the IO has come before the court and said that, my lord, my bail should be cancelled because I'm not cooperating with the investigation. And my lord, this is a very interesting part, my lord. I fail to understand a document, they said that on 21 and 22, as per section 91 notice, I should appear. I came on 21st, my lord. I have placed the boarding flight tickets and all that. On 22nd, I appeared with my lawyer from Delhi. They have seized the documents from me. That is, I placed it on December, my lord, precisely on December, my lord, affidavit which I filed before this honorable court, my lord. That is, my lord, 3/12/2012. My affidavit, my lord, filed on 3/12/2012. Lordship may take it, my lord, filed on 5/12. Signed on 3, filed on 5/12. Lordship may see page 313. As a lordship.
Just one. Yeah, he was also. Affidavit filed on. Affidavit filed on.
My lord, it's on 5th of 5/12, my lord. Lordship may see, my lord, page 313. In fact, lordship may see 312, my lord. I came. That's my flight ticket, my lord. Page 312, my lord.
$313.
312, lordship may see my boarding pass. I came to Guwahati, that is Anjuman Kumar Sharma, lordship may see Air Asia flight. on 22nd November 2020, middle portion, my lord.
Yes.
Now, Lordship may see, I appeared before the police station, my lord. Before Inspector Subhash Chandra Das, who is the present IO of the case, my lord. Now, Lordship may say date of our seizure 22/11/2022. These are the documents seized, my lord. Then Lordship may come the second page, my lord, page 314. Lordship may seizure witness Kumar Gaurav advocate, so his mobile number is also there, my lord. Lawyer's chamber, Rohini Court, Delhi. Then Chief Inspector of Police, Chaigaon Circle. This is the signature. The original copy, Lordship may see at page 315 and 316. It is a photocopy of the original, my lord. Now, my lord. And then Lordship may see page 159, my lord. The second, the additional affidavit which was filed previously, my lord, page 159. Because I appeared on 18th, my lord. 18th, my lord, 3 times I appeared before the police, my lord. One on 21. Lordship may note 3 dates, my lord. I appeared before the IU, my lord. I got a bail on 17 March 2022, my lord. And I required to appear within 7 days, my lord. So I appeared on 21 March 2022, my lord. First date, my lord.
First date is
21 March 2022.
That is page.
That is page, my lord. Lordship may see my boarding pass at page 147, my lord. 3 boarding pass, my lord. 3 persons were accused, my lord. Anjuman Kumar Sharma, Amit Sharma, and Gopal Krishna. So Lordship may see the boarding passes at page 147, page 148, and page 149.
Yes.
3 pages, my lord. Page 1, these are boarding passes on 21 March 2020. So I appeared on 21 March for the first time, my lord, within 7 days, as per the direction of the court. Now, thereafter, my lord, I wrote 3 letters, my lord. Lordship may see page 150, 151, 154. Because I was not hearing from any, my lord, there I've been enclosed, except the document at page 150, my lord. I've placed all document with the postal receipt, my lord, sending to the IO, my lord, that whether my requirement is there or not. Lordship may see from page 150 onwards.
150 then.
My lord, 150, 151, 154, then 156. Of course, 156, my lord, I appeared before IO on 18/11. That your lordship may see page 159, my lord. Now, lordship may see page 159, my lord. Section 91 notice.
Just a moment. Just now, after this page 55, what is the next page you are showing me?
Then, after 155, Lordship and Lordship may come to page 158, my lord, because 1811 I appeared before the circle. That 158 is my lord boarding pass on 1811.
Yes,
Has a Lordship got it? Page 158, my lord.
yes,
Now, my lord, I appeared, my lord, or the Lordship may come to page 159, my lord. That is the section 9. After I appeared, my lord, they give me a section 91 notice, my lord. Page 159, my lord.
yes.
So this is the second date I appear, my lord. That is 18/11/22, my lord. So Lordship may see the notice, my lord, to Anjuman Kumar Sharma. Case number has been mentioned on top. Regarding submission of documents, you are hereby directed to appear before me on 21/11/22 or 22/11/22 at my office chamber, Chaigaon, with all relevant, Lordship mark this, with all relevant documents in respect to Dr. Biswas medicine logo and trademarks. Now, my lord, I received this on the same day, 1811, my lord. Lordship, my signature is there. Now, my lord, on 21, now the facts is very interesting, my lord. On 21, my lord, I come to Guwahati, my lord. Lordship may see my boarding pass at page 312. This is the additional affidavit I filed, my lord.
312,
my lord. This is my boarding pass, my lord. Sir Anjuman Kumar Sharma. This is the third date I appear, man, on 22. That is my lord, additional affidavit, the second additional affidavit.
Just a moment.
My lord. 22/11/22, my lord. I appeared, my lord. This is the third date, my lord.
Yes,
And my lord, I submit documents file. Lordship may see page 313. And the IU, my lord, Subhash, Inspector Subhash Chandra Das, he sees the documents, my lord. The documents mentioned, my lord, detailed articles that Lordship may see, so and so, so and so, and Lordship says 314 page. This is not, my lord, that he only sees in presence of witness one advocate from Delhi who accompanied the accused, my lord, the petitioner, page 314. So, my lord, seizure has been done, my lord. Now, there is another seizure list, my lord. Lordship may come to page 380, my lord.
$318.
380, my lord. But that will, Lordship may say page 367, my lord, because there's some mismatch of pagination, my lord. Lordship may see the document, my lord. This is my affidavit in reply. Page 367, Lordship may see. No, sorry, three. Oh no, Lordship file maybe 367. Well, mine is 380. Has a Lordship got it? Has a Lordship got it? In Lordship file, it may be 367, my lord. I'll correct my pagination, my lord. Actually, the two affidavit was missing in between, my lord. So that's why, my lord, I've calculated those and put my pagination. So therefore,
Okay, that is annexure 2.
annexure 2, yes, my lord.
Ah, yes, it is
But this is-
367 here.
My lord,
367 here.
yes, 367. I've corrected while coming in the morning, my lord. Lordship may see seizure list. Here, my lord, date is not given, my lord. I've checked up. But then SI Nani Gopal Sarkar, he was the earlier IO, my lord. He also sees some documents, my lord. The original I have annexed, my lord, page 38. It should be.
Yes,
It should be 368, my lord. This is the original, my lord. The witnesses are also there, my lord. The same lawyer, he came, my lord. His name is also figured, my lord, in that particular seizure list. And this is the handwriting of the IO, my lord. SI Nani Gopal Sarkar. The two witnesses, my lord. Amit Kumar, Sheel or something, my lord. And Kumar Gaurav, advocate from Delhi, my lord.
yes.
Now, Lordship will see very interesting. The IO comes independent.
A bill matter with 400 pages is otherwise also interesting.
Yes, interesting, my lord. It's more interesting, my lord, now. But how come, my lord, this could happen? I was wondering, my lord. In fact, yesterday,
If everything was simple in a bail application, we don't need a senior lawyer in both sides.
now, Lordship, I really, my lord, I don't know. But this is actually personal fight, my lord. Because my friend, senior friend is there, my lord, objecting bail. I'll show why he is objecting and what is the reason behind it. Now, Lordship may see now how the people have been, my lord, functioning, and this IO is working, my lord. I'll put this affidavit, the copy is not there, my lord, but I'll read it, my lord. Ashi Subhash Chandra Das so and so, my lord. And this is filed, my lord, on 9th of March 2023. My there on the records, except the second seizure list was not there, which I filed in the month of March. Actually. Now, para 3, my lord. That the person to the direction of the Honorable Guwahati High Court, the accused petitioner has appeared. During recording their statement, the accused person stated that the medicine recovered in their rented house is not belong to them, and they were not aware about this. However, during investigation, the godown of the petitioner was searched at Haryana. It was searched at Haryana, my lord. No dispute to that. And some brand of medicines were recovered. In view of the above, the petitioners have not cooperated with the investigation. They try to mislead the investigation process by making false statement. Where is the question, my lord? You see some medicines at Haryana. We are saying that we have a license. I produce all licenses that to manufacture the medicines. I'll paste one by one. Then, my lord, this is the important part. Lordship, there's something wrong, something fishy. I think this IO should be called. That both accused petitioner did not cooperate with the investigation and did not furnish any documents which were sought to be given notice under section 91. Did he was confronted with seizure list because we filed it earlier that this is your signature? The law appeared either this is the fourth seizure list. He has saying a blanket, did not furnish any documents in spite of 91 notice. I didn't understand this part. You're asking for cancellation for such a serious matter. You're taking the life and liberty of a person on making a false statement here. This IO should be brought here on personal appearance, my lord, and he should be shown this document, whether this document is not a part of the record.
And what will you do in trial?
No. I don't know. My lord will see how this IO is behaving and whose BS, my lord. How could my lord, Lordship, I've shown seizure list, my lord. Documents were seized, my lord. Signature of the witness. IO signature. The same person signs that seizure memo. This particular IO, my lord, and he files bail petition that did not furnish any documents which were sought for giving notice under 91. 91 lordship seeing notice. How, my lord? I put a question to myself. You are asking for cancellation of whole life and liberty of a person like this, when the record speaks otherwise. And my friend must have asked the IO when you come to sign this affidavit that this is the document. Either you deny that this is a false document prepared by the petitioner, let him go bar. The law should go to the bar, behind the bars, because of preparing a concocted document and placed before the court. That is not the case. So, my lord, so for investigation part, I have explained it, lordship, that thrice we have appeared, thrice things have noted, seizure has been made. Earlier, IO also made the seizure, and these are not part of the record. I think lordship will take a serious judicial notice on this, my lord. Definitely, my lord, why not? So nobody can come just like casually and say that bail should be cancelled and no document has been given. So this is the matter of investigation part which I will do. Thank you. Now, my lord, I find a reply. Lordship may see. That page starts from lordship, the 367 afterwards, my lord. They said that my goods were recorded from Haryana. Now, my lord, I place all documents, my lord. Lordship may see one by one document, my lord. After the seizure list, my lord. After 367, 368, 369 onwards, my lord. Dr. Biswas Medical Company, Haryana, my lord. My registration certificate, my lord. Then lordship may see the next page, my lord. Anjuman Kumar Sharma, trade name Dr. Biswas Medical Company. Then lordship may come to next page, licensing from State Licensing Authority, my lord. Page 385, minus 385.
Basically, we just take note that your documents are there, because you
Yes.
won't appreciate documents in our bail application.
No, what I'm place that I have so far the goods seized from Haryana. I have all the documents which I placed before the authority council. That is what basically. So there is no illegality in it, my lord. You have seized, but you have not said after seizure what you have done, and you came on the basis of that to cancellation of my bail. Everything, my lord, all documents are in it, my lord.
Okay.
Now lordship may come, my lord. Well, my written argument has come. I'll just.
Yes.
Only, my lord, I'll subsequently I may be allowed to correct the pages, my lord, because I'll just put the mark with the pages may not tally, my lord, some of the pages.
That's all.
No, this is the investigation part, my lord. And then lordship, I've stated all facts, my lord. Here is the case, my lord. The informant, he is also manufacturing of Biswas products. We also do it. There are others also do it. Page 125, lordship may see 125 bail. Page 1%. So this is the matter of Trademark Act. We download from some website paper. Now, lordship may see there are many who do this business under Dr. Biswas. Now, serial number 5, your lordship see. Ashim Kumar Biswas. The application number on the left hand side, refused. So he is also subsequently he got a remark. I've not seen that. And by as I showed earlier, that the commercial courts, they have moved commercial courts one after another, suppressing earlier facts and all those things, and they got an injunction which we are likely to vacate. Now, there is not only one, if you lordship see, one Suman Biswas on the page 125 already. Biswas is the name. Then Ashim Kumar Sharma refused Biswas good health device. Then Ashim Kumar Dr. Biswas. Then Mr. Gaurav Gupta,
We understand
Biswas good
there
health.
are other people also.
And that's all. So there is a difference. I last occasion already I showed you lordship with regard to finding of commercial suits, rare bail, and all those things. So if there's admitted there's a dispute between both the parties. Now, interestingly, an FIR is lodged by the that is lordship is there if it is not on record. That FIR lordship this is the file now. This is not on record. This so he lost. He is the informant, Lord. He lost the FIR. And then they ask for cancellation bill. FIR is there number X document number 9.
This is not document number 9, it should be 11.
11. So information regarding threatening given by the informant and the accused in connection with Bogo PS case number 105. With reference to the subject matter, I have to order to state that I informed the FIR was lodged on 3/3/2022 against the accused person, namely Anjan Kumar Sharma, and then when occur this witness knows that I will be traveling. How come this witness knows that I can I will be traveling on 7/12/22 near Kumarkara village about Kusin to us. This is I reply. I have given a reply to
Okay.
now the other documents. So other documents is there. That
What is the point you are trying to make?
I'm telling my. That's the point. On 17, I was not there. 17.
No, that is okay. Plea of alibi will be in the trial, not for the purpose of
Yeah, very good.
examining the bail. Plea of
So,
alibi is a matter of trial.
understood.
You are there or not, can't be decided in a bail application.
See, that's okay, but if you have to take that into consideration, then is that required to be called? I'm not well actually.
Okay. You need water? Mr. Roy?
Yeah.
You need water? Okay. Yes.
My lord, I have filed my lord an objection, Lordship.
Hmm.
My lord, in this case, Lordship, this honorable court has granted him pre-arrest bail, Lordship, for the purpose of my lord, to cooperate with the investigating officer, Lordship. When accordingly he appeared, Lordship, what statement he has given, Lordship. I am not reading in the open court, Lordship. He has denied that the medicine seized from the Lordship Boku house. It was not belongs to him, Lordship. The first and first submission, Lordship. Secondly, Lordship, one my lord, tenancy agreement was, my lord, they have submitted, Lordship. In the said tenancy agreement, Lordship, it was specifically mentioned that for the purpose of commercial purpose, and it was, my lord, what it is stated. My lord, in the second paragraph, Lordship, page number 2. And whereas the tenant approached the landlord to let out the said commercial premises for him for exclusive commercial purpose in the name and style of Zenith Pharmaceuticals. My lord, the products of Zenith Pharmaceuticals are different. And the products which were, my lord, the subject matter of the FIR, Lordship, it is belongs to Lordship Dr. Medical, Dr. Biswas Medicine, Lordship. Now, Lordship, what has been seized, these, my lord, as my learned friend has submitted, Lordship, as far as seizure. My lord, these are all the Lordship certified copy, Lordship. Accordingly, Lordship, this person was issued notice so that he can produce the original document, Lordship, and for the purpose of examination, Lordship. But till that, he has not produced the original document. Now, Lordship, IO, with the permission of the superior officer, Lordship, he visited the Haryana, Lordship, wherein his mother, this mother, Onjumar Kumar Sharma has given some address, Lordship, and his Gudan was searched. The same medicine was recovered from Haryana also. My lord, wherein the levels of discharge healthcare was mentioned, Lordship. My lord, in investigation, Lordship, he was directed to, Lordship, cooperate with the investigating officer. So the Lordship, the IO can proceed with the investigation, Lordship. Now, what is the, my lord, cooperation, Lordship? Well, he has to give the proper, my lord, reply to the answer of the IO, Lordship. He has to give the, my lord, documents which are IO sought for. Well, a question of, Lordship, using the trademark is a different aspect of the matter, Lordship. If he is authorized, he can use. If he is not authorized, he cannot use, Lordship. But what I have seen from the case diary, Lordship, this Biswas Medical, my lord, what the medicine was recovered from his Gudan, that belongs to, Lordship, Biswas Healthcare, Lordship. And the FIR, it is very much clear, Lordship, what stated in the FIR. Lordship may kindly. Peruse the FIR, Lordship. I'm just reading the second part of the FIR. So I'm sorry, it was the first part of the FIR. That the above name accused has been fraudulently used the trademark Dr. Biswas, which is the trademark of our company, and the trademark was obtained by the company on 23rd August 2017 under Trademark Act 1999. Moreover, the accused, by using the trademark, continuously manufacturing the like products of the company, that is good health capsule, good health syrup 500 ml, left pro cure syrup 450 ml, etc. And using the said trademark package and medicine and stores the same in a godown of Amin Rafiqul Islam, son of Naran Ali, village so and so, under Buko Police Station, Kamrup district, by taking the godown on in rent. Presently, the accused persons are selling the product in market, infringing the trademark act and drugs and cosmetic act, and as such, they cited the company, etc., as well as with the innocent public. This is the allegation made in the FIR. Now, pursuant to that, he appeared. I am not denying that he has appeared, but he has not cooperated. Question is that what the document IO has sought, he should have, my lord, furnished the document. We will also have said that he has cooperated with the investigation.
You have a copy of your objection?
My lord,
You have a copy of your objection?
yes, lordship.
But Mr. Burwa, just tell me from my understanding, supposing a man has a trade license
My lord,
to sell vegetable,
my lord,
municipal trade license he has to sell vegetable,
my lord,
correct? Now he is selling fish there,
my lord,
correct? Instead of one or two pieces of some vegetable here and there, he's selling fish there,
my lord,
and he's a big trader in fish.
my lord.
Now what happens? How will the police investigate this matter?
My lord, if his trade license is specifically mentioned that he is authorized to sell vegetable, lordship, then he cannot sell fish, lordship. That is my lord, my
It's
understanding.
okay.
goes,
But
lordship.
what will the police do then?
Well, the police will definitely, lordship, will ask the, my lord, when you are authorized to sell vegetable, why you are selling fish?
Okay, so you okay, that is one. So therefore, let us say we change the example. Mr. Sheikh is there. I'm just using his name just for the purpose of what you call bringing spice to the statement. Let us see he files his income tax showing yearly professional income of 1 crore rupees. Correct. Now, police looking at him perceives that Mr. Sheikh would be earning not more than not rupees 1 crore. His professional earning would be 2 crores. So what will the police do then?
And the police will
Income
have
tax
to-
return 1 crore,
My lord,
Mr. Sheikh, professional income. Now, police suspects that looking at Mr. Sheikh, always pick and span, always in a fresh mood. Police suspect that his income is 2 crore rupees. What does he do?
my lord, in that case, lordship, police probably have to, my lord, rely on the income tax certificate, lordship, income tax return and everything.
No, but in both the cases, police has no jurisdiction. If he's selling, he'll just inform the GMC that he's selling something else.
My lord,
For income tax, he'll have to go then report it to income tax.
my lord.
The police can't interfere in these cases.
My lord,
Both the
definitely,
cases,
lordship,
they can't come in.
the question is that the police will, my lord, authorize to interfere only when there's complaint or any, my lord, FIR is lost. Suppose the
No,
vegetable.
I am on the second question. First example. You see, a man is having a trade license or selling of articles of company X.
Right.
In his godown, goods of company A is available.
My lord.
Now, can the police investigate that?
No, question is that lordship, the section 420 is there because he is not authorized to sell the, my lord, medicine of discharge healthcare, lordship. He has
That is what
manufactured the label.
the government of India,
My
in
lord.
its wisdom, has in the Drugs and Cosmetic Act, is requires that all these state governments will have drug inspector to do this checking. The checking has to be done by the drug inspector. How will the police step in? Tomorrow he will visit this, tomorrow he'll visit a pharmacy, the third day he will visit a pawn shop. saying that well, Burmese Supari can be found here also. So I read this place also. So will it not be a chaos?
No, my lord, the question is.
Somebody's jewelry of X is stolen. He will come into your house. I want to examine your wife's jewelry.
Question is that, Lordship, when a FIR is lodged, Lordship, the police has to investigate, Lordship.
No, I understand.
My lord, that
But to look at the implication which will happen, police may enter into the house of anybody. Gold is something which can be melted. So now we will say that, well, Mr. Barua, I have seized your gold. I have to get it checked whether this gold was the same gold melted and prepared a new jewelry. So I seize your article. How far that can be permissible for the police? Because last time also, yesterday also, I told a story. There was when I was a fresh entrant in the bar, there was a case where there was a fight between two coal barons. At that point of time, names you will recollect because you were there. To fight of two coal barons. And one coal baron's wife eloped with another. And then she lodged an FIR in Basista police station saying that she has lost her Almira key. And the police conveniently comes, breaks open the house, enters, and finds a revolver in the top of the Almira. You remember that case?
Beltola case, my lord. Beltola case.
Huh?
Beltola case.
The coal fire between two coal barons. So that is the first time I saw, or I heard, in fact, that the police for the loss of a key, had in fact raided the house and then found that key, opened the Almirah and found a revolver also. Not Basista, Beltola. You are right. You are absolutely right. It's okay. This objection, there's no document here.
The document, my lord, along with the objection, we have not filed any document, Lordship. Because
Okay.
we are submitting this objection on the basis of the, my lord, whatever the investigation so far, Lordship, my lord, during the, my lord,
Okay.
in today.
Yes, Mr. Chairman.
Yes, my lord. I am appealing for the informant, my lord. I am mainly on 2 points, my lord.
Yes.
One is, my lord, that condition of violation of condition of bail, my lord, that would this entitle him for further extension or for the grant of bail. One. Number two is, my lord, that threat issued to the informant under showing of APS, my lord, where FIR is filed. And against this objection, there was no counter by them, which I have filed.
Pardon me, please come again.
My lord.
Please repeat again.
The FIR was filed by me, issued by the
Yes.
police.
Yes.
Investigation going on. And my lord, against that objection I filed, my lord, that there is no counter by them, definitely denied. And he has put his number of my lord tickets that he was in Haryana, but the names of these persons do not appear. And even there on their own admission, my lord, even if one of them had appeared, Anjuman, not the Amit, the other one. So there was clear violation because both had to appear and give the statement. And the section 437 of the CRPC, my lord, subsection 2 and 438 subsection 3 clearly says that the condition imposed by the court must be adhered to and respected. But in any case, they are desperate. There's a desperate element Otherwise, they, in spite of the minor injunction, clear injunction granted by this commercial court in Delhi, Delhi High Court, they are going and producing mallet. Now we came to mallet, they are mixing steroids. Of course, police will send it for forensic laboratory mallet. We came to know that they are mixing steroids to make it strong. And it may have not only Assam and Haryana, it may have national impact. Where they are producing. The factory was in Haryana. And where they are hiding the medicine mallet, I have in the written submission I am giving. They were hiding the medicine mallet. There are lots of the Boko and Nagarwara border. Deep minority area near Brahmaputra. Not in the Boko center also. Not in Guwahati. Not in Gwalpara. They found selected place where no police, nobody could know. Until we filed, when we suspected that there is something going on in the market. And there was a clear injunction by the court, High Court of Delhi. They cannot use the name Dr. Biswas. Yes, that I. In my objection, I filed my lord. I have in the objection, I have shown the injunction order. Order is 16/3/2022. Page 313 of my objection.
313.
Annexure X4.
313.
My objection, madam.
Yes, 313.
Now I have given extra copy mallet because it is not
Yes,
tagged
yes.
with the
Yes, yes.
in that mallet. It may be page. In the mallet, order is 16/3/2022. Then also now also they are going producing mallet rampantly elsewhere. And the relevant paragraph is mallet. They have 16. They have least respect for the court mallet. Either Delhi High Court or Guwahati High Court. There was a clear order by this court on 17/3/2022 to cooperate with the investigation. Not only appearance mallet. Appearance is simple, but cooperating and furthering the document and other things are necessary when the police wants. And they are believing the police. Agreeing the defendants and all other acting for or on their behalf are restrained from manufacturing, selling, and any medicines of pharmaceuticals, formulations, including Ayurvedic medicines, under the trademark logo, training style, Dr. Biswas. What they are using? Dr. Biswas Medicare. My name is Dr. Biswas Good Health. I have in the this short note I have given first page. Dr. Biswas Good Health is mine. Description. They are using Dr. Biswas Medicure. And a man from Haryana using the competition of Calcutta and found Dr. Biswas only because my medicine is famous in India. So they want to produce a spurious medicine. Maybe it may be drugs, narcotics, anything. It needs police investigation. The trademark session will dealt with the trademark department, copyright department. But whether this medicine, how far is harmful to the society, how far it is injurious to the health, it is part of the police work. Just now I had one swallowed that our objection. Extra copy matter.
Yes.
In that. And dragging the matter mile one after another date wise, but 1 year, 15 days. Their thinking was that in the long run, the evidence will disappear and the evidence will evaporate in the air. I also annexed my trademark. My license is valid till 27/8/2027. Your lordship has not got my lord.
Yes. Yes.
So, my lord, they are not only violating the bail order, my lord, the condition imposed, but also the order of the Delhi High Court, my lord. And going and producing using my name, Dr. Vishwas, which is my logo, permitted logo, their marked logo. And the medicine produced now we came to know is a mixture of steroids that would enhance the temporary power in a man's body. And what else we do not know until my lord, the police sends the medicine for examination. Not only in here in Haryana or elsewhere, they might be producing because since they could infiltrate from Haryana long distance to Guwahati in the Nagarwara Woko border, the flood affected area, taking a house in rent from one Amirul. And since they are not cooperating, my lord, they are who violate the court's order, my lord, are not entitled to any sympathy or any consideration by the court, my lord, in bail matters. They must cooperate so that the investigation comes to conclusion and the trial starts. And writing a letter, long letter to Inspector Police, first time I have seen an accused writing the letter that I appeared in your office on such day. If he has appeared, it is in the case diary. If he has done submitted something, it is in the case diary. Writing a letter from somewhere and saying that I appeared before you, I did this, that. That means they are evasive. When court's protection is there, they must have appeared. And it is only by that too only Anjuman Sharma, not Amit Sharma. He produced the air tickets and other things, taxi drivers certificate. These are the matters not to be relied in bail application. What is primarily relied on is the case diary and submission of the IO, sorry, PP. So, my lord, it is a case. They cannot be left at liberty. They are desperate. We have a trademark. I annexed the my lord in my objection also 311 our trademark obtained from the Government of India website, Ministry of Commerce and Industry. Annex X2.
Of the today's affidavit.
Yes. X2 and 3, X3, and the validity, my validity up to 23/8/2027.
Your trademark.
Yes. 23/8/2027. You will also find at X3 annexer. Wordmark Dr. Vishwas. This is the permitted trademark I am using, and they are using the same name, Dr. Biswas. There is clear case of cheating. Of course, the police has not framed any charge under my lord, they have not added 460 or 471. This is also case of 460 or 471 forgery.
That's all.
And their application was objected to and it is not granted yet. They are producing without any license, without any GST, even GST is posed. So, my lord, these are the submissions, my lord. All these things will show, my lord, the criminal intention and motive of the petitioners. And they cannot be entitled to PNR on further bail. Oblige, my lord. My submission may be noted, my lord. That's it.
Patent Act. Patent Act. You said that you have a patent. You have a patent for that medicine 312? No, Mr. Sharma.
Yes.
Page 312, what was that certificate?
Yes.
Patent
Yes, my lord.
or trademark?
X3, yes.
No, it's a patent or a trademark.
Trademark, word mark, Dr. Biswas, application so and so. Dr. Asim Kumar Biswas is the owner, my lord. And rectification file valid up to use since actually from 2/29/8/2011 valid up to 23/8/2027. This is from Government of India online website.
You know something, I'll show you.
Trademark Act, my lord. Section, my lord.
Oh, you have that book? Okay. Section 115.
Yes.
4.
Yes. Any police officer not below the rank of deputy superintendent of police or equivalent may, if he is satisfied that any of the offences referred to in subsection 3 has been in are being or in is likely to be committed, search and seize without warrant the goods, die, blocks, machines, plates, other instruments or things involved in committing the offence wherever found, and all the articles so seized shall as soon as practicable be produced before the judicial magistrate of the first class or metropolitan magistrate as the case may be, provided that the police officer before making any search and seizure shall obtain the opinion of the registrar of the on facts involved in the offence relating to trademark and shall abide by the opinion so obtained. Yes.
So jurisdiction is with the deputy superintendent of police.
I don't know whether the maybe man, because in like in NDPS Act, my lord, even SI Act, but under section 41, 42 says NDPS Act, my lord, any officer above the peon, rank of peon, if authorized, can act. Otherwise, it is the deputy.
In patent, it is in trademark, it is not there. State government has not come up with an amendment.
No, not amendment. There may be general notification also.
It can be. A notification will not override the act.
Yes.
You know that.
Yes.
Not below the rank of deputy superintendent of police.
Yes. No, here, whatever matter, that so far trademark act offense is concerned, that is, police is not dealing as such. What police is doing under section 120B and 420?
That the jurisdiction is not there.
No, if the case is purely under the section 63 of the
No,
trademark
that's what
act,
I'm saying. I'm just showing it to you.
yes,
You don't want an observation from the court, but it will scuttle your prosecution.
yes,
But the fact is that once there's a, that's why I gave that example. Two examples I gave for a particular reason.
yes,
Number one, I gave about this GMC
yes,
vegetable. Second example I gave was of a specific act, that is a Drugs and Cosmetics Act. Because once it is an offense which is triable under that act,
then that department is to do.
then that department has to do. So the
But here,
principle, same principle will apply there. 420, in guise of 420, the police cannot investigate trademark.
no, trademark, they are not investigating. They are investigating the offense, whether the things are spurious or not. So they have simply seized it.
That is drugs.
They have simply seized it, my
That
lord,
is
because
drugs and
they are not,
cosmetics.
since they are not cooperating.
That is drugs and cosmetics.
Yes.
Where does the police get this jurisdiction? That is why I asked the specific question.
Once the FIR is filed, my lord, police has to act.
No,
Yes.
no. Now let us see. Today I go and file a FIR saying that X, who is an MP, was wrongly elected. I file an FIR. What does the police do?
And in that case, it is
So-
prescribed.
So hands are tight. You can't do it.
But there are some lawsuits will also affect the trial ultimately.
No, that's what I'm saying. I'm not saying anything,
Yes.
but
But I am not on that matter. Even here, not in the merit of the case. What I am on is, my lord, non-cooperating in threatening notice. Section 437. I am relying on primary, I have in the, of this one I have said, my lord, 437 2, we will kindly see. 437 3, CRPC. 437 3.
yes,
Court shall impose the conditions such as that such person shall attend in accordance with the conditions of the bond executed and in under this chapter. That such person shall not commit an offense similar to the so and so which is accused. But now he has committed more serious offense of threatening, that is second part of 506, which may extend to life. Suspect or the commission of which is suspected, and that such person shall not directly or indirectly make any inducement, threat, or promise to any person acquainted with the facts of the case, so as to dissuade him from disclosing such facts to the court or any police officer or tamper with the evidence. So a lordship was granted bail. Otherwise, section 3, 6 is now.
437 will it apply in 438? Will it apply?
4, my lord.
Conditions of 437 will it apply in 438?
In 438 also. Subsection 2. Yes, general conditions, my lord. Subsection 2. Roman 1, 2, and 4.
Subsection 3 of 437. Okay.
Yes, and subsection 2 of 438.
Okay.
Otherwise, section 63 of the Trademark Act. I think it is a very good offense otherwise.
No, not section 3.
109, 109. Just a minute, my lord.
It will be 103 proviso.
In,
Because it's a sentence of imprisonment for a term less than 6 months or fine less than
yes,
50,000
it is
rupees.
available. So I am not on that. That is otherwise not available by the police or anybody. 104 penalty for selling goods and so and so. Under 104 of the trademark. Then my lord. Yes, section 63 of the Copyright Act.
Okay.
It is also same.
Copyright
6
is the
months.
same.
Same. So my lord, I am not on that. I am on my lord. This 420 and 120B.
Okay.
And there should have been 460 and 471 also. That is not held by the police. 428 later on. And my lord, that violation of the condition of the 438 2.
Okay.
433. So
Hmm.
my lord, the bail should be rejected. They are not entitled. They are not entitled to any sympathy with the court,
Well,
even if for the little fraction on their part.
Mr. J. Roy, Learned Senior Counsel, assisted by Ms.
Peanut.
Learned Counsel for the petitioners, and Mr. Ajay Barwa, Learned APT for the state, as well as Mr. R.P. Sharma, Learned Senior Counsel, assisted by Mr.
Devashish Dole.
Mr. D. Dole, Learned Government Advocate, sorry, Learned Counsel for the private, for the informant. Next. By filing this PRS bail application under section
My lord.
438,
May I leave the court?
438
He will be
CRPC,
there.
the petitioner is seeking PRS bail in connection with Boko PS case number so and so. Page 2. No, page 1, so and so, related so and so. Copyright Act, copyright. Oh. Where is the previous bail order?
17 years. Seventeen 2022.
No, page. No, the previous bail order, page. That's correct. On 3/3/2022, an FIR was filed by the informant Musa Hidul Mushahidul Islam, alleging that stating therein that he was the counsel, he was the advocate of Dr. Ashim Kumar Biswas, from a proprietor of Dr. Biswas Medicare Company. Situated at Bara Kantila, BARA, next word, ANTHITHALIA. District 24 Pargana within bracket North. And Dr. Biswas Good Health Company, B-43. You just don't get that. Kalyanpuri, New Delhi. Kalyanpuri, Delhi.
Yes.
First, it was alleged that the petitioners were fraudulently using trademark of Dr. Biswas, which is the trademark of their company, and manufacturing deceptively similar products, thereby infringing the Trademarks Act and Drugs and Cosmetic Act. And thereby the company was cheated. Company as well as innocent public were cheated. Full stop. Yes, where is that bail order? Earlier? This could be an interim order dated 17/3/2022, granted interim bail to the petitioners amongst others, with the condition that the petitioners shall appear before the IO within 7 days and shall cooperate with the investigation. The case presented by the petitioner is that the petitioner number 1 the petitioners traveled to Guwahati from Delhi on 21/3/2022 and had appeared before the IO on the same day. So in this regard, the Donor Senior Counsel for the petitioner is referred to the boarding pass at page 147 and 148 of this bail application. It is also projected that on 18/11/2022, the petitioner number 1 again came from Delhi to Guwahati, for which reference is made to the boarding pass at page 158 of the pleadings. And by referring to notice under section 91 CRPC dated 18/11/2022, available at page 159 of the pleadings. Which was received by the petitioner on 18/12/2022 at the police station precinct. The petitioner was directed to produce all the relevant documents in respect of Dr. Biswas medicine logo and trademarks. The Granite Senior Counsel for the petitioner submits that all relevant documents were produced before the IO. First of it is by referring to the boarding pass of the petitioner number 1, available at page 312 of the pleadings. It is submitted that on 22/11/2022, once again the petitioner number 1 appeared before the IO and submitted the certified copy of all the relevant documents. And in this regard, the reference is made to the seizure list available at page 315 and 316 of the pleadings. Showing that the documents were seized on 22/11/2022 by Inspector Subhash Chandra Das, SHUBAS, CH Das. Where is that earlier seizure list? 367.
No, this is
367.
this is
The Learned Senior Counsel for the petitioner is also referred to a seizure list at page 368 of the pleadings to show that although the seizure list does not contain a date, however, the seizure list was prepared by the then in charge of Sontoli outpost under Poco police station, by the then SI Nami Gopal NANI GOPL Sardar SAR AR, wherein GST registration certificate, license of manufacture, and an order passed by the Court of District Judge within bracket Commercial Court number 3, Delhi, were seized. So it is stated that the seizure was made in the presence of the advocate for the petitioner, whose signature is available at serial number 2 of the said document. And it is submitted that in the seizure list dated 22/11/2022, the same lawyer was the witness. Full stop. Referring to the objection filed by the state, why it is submitted by the senior counsel to the petitioner. That in the said objection, the IO has recorded that the accused petitioners had appeared before him, and the statement made by the petitioners is recorded therein, and it is further stated in paragraph 3 of the said objection that some recoveries were made when the premises of the petitioners were searched at Haryana, and same brand of medicines were recovered, and that they denied that the medicines recovered from the rented house did not belong to them, and therefore it is posited that the petitioners have not cooperated with the investigation. In the objection, it is also stated that the documents were not furnished as sought for by giving notice under section 91 CRPC, and on both the counts, it is submitted that when the petitioners appear before the IO and the IO records the statement, and that the notice and on receipt or notice under section 91 CRPC, one of the petitioners have furnished the certificate copies of all the documents they have. Now it is not open to the IO to say that he is not cooperating with the investigation. Next one. The learned counsel for the senior counsel for the petitioner has submitted a written note of argument which is kept as a part of record. Next one, the learned senior counsel for the informant has submitted that the petitioners are using the informant's name, logo, trademark, and trading style as within inverted comma Dr. Biswas bracket close, and within inverted commas Dr. Biswas Medicure Company, MEDICURE Company, inverted comma closed, without valid license, trademark, etc. So, by referring to the by the referring to the copy of FIR dated 19/12/2022. Which is that page? Mr. Dole.
This is lordship, documents number 11, lordship.
No, page that.
Page lordship, that copy we have, extra copy we have find is going to documents number 11.
Document by X1. Page 310 of the pleadings. It is submitted that the advocate of the petitioner, the informant, was traveling from traveling to Nagaon, and the petitioners intercepted him on 17/12/2022 at Kukunmara Bridge, Chaigaon, at about 3 p.m. and abused him with filthy language. And he was threatened that if case is not returned, his family members will be shot. Accordingly, it is submitted that the petitioners have violated the conditions for grant of bail. Moreover, it is submitted that there's an injunction in favor of the informant granted by the High Court of Delhi at New Delhi in CS within bracket COM COMM 160 of 2022. By order dated 16/3/2022, and that with the recovery of medicines, which is deceptively similar in nature, the petitioners are violating the orders of injunction of the passed by the Delhi High Court. It is submitted that by recovery of medicines at Boko, it was apparent that the petitioners were dealing in fake medicine, and they have even counterfeited the GST application of the informant. The donor senior counsel for the petitioner has, informant has also filed a note of argument, which is kept as a part of the contract. Next paragraph. It is noted that the IO has admitted that grant of interim bail by this court, the petitioners had appeared before him. The seizure list available at page 315 and 16 of the pleadings is a testimony of fact that the circle inspector, namely this is Subhan Chandra or Subhas, page 1315. Is it Subhan, SUBHAN? It is not S, I think.
It's my own. Yes, boss.
No, it appears to be N. Page 315. Subhan, Chandradas.
Subhasan Das Megan.
No, that is your typing, but Hindi, that is handwritten one. Subhan is N. In your objection, you have written what name? Subhan, Subhan, not Subhas. Subhan. Chandradas.
He's not keeping well. The doctor is outside. We'll just take him. My lord may continue with him. He's not keeping well. Doctor is outside, my lord. We'll just have him. My lord will continue.
He's excused. He's already troubled with 400 pages of pleading in bail. As to the contents of notice under section 91 CRPC, the investigation officer, who is the Circle Inspector of Police, Chaigaon Circle, has required the following. Inverted commas. You are hereby directed to appear before me on give a dash 21/11/2022, sorry, 21/11/22 or 22/11/22 at my office CI capital Chaigaon CHHAYGAON at 11 a.m. with all relevant documents in respect of inverted commas Dr. Biswas bracket closed inverted comma closed medicine logo and trademarks. This is flagged page 159. The said notice is received by the petitioner number 1. Under such circumstances, comma, in the petitioner has produced as many as certified copies of as many as 9 documents. It is unacceptable that the petitioner has not cooperated with the investigation or has not produced the relevant documents. With the I was dissatisfied with the documents produced, comma, the petitioner can always be asked to provide a specific document. Merely because the IO suspects that the petitioners are misleading the investigation. Come on. And arriving in the conclusion that he is making a false statement. Yet in a case where Copyright Act or Trademarks Act is allegedly violated, would not require a custodial interrogation. First of all, in this regard, we may take note of the nature of punishment which is prescribed under the Copyright Act as well as the Trademarks Act. Next will be insofar as the contents of the FIR dated 19/12/2022 is concerned, the court finds it the court finds the contents slightly. No, the court reserves this comment on the story that the advocate of the informant was traveling from one place to Nagaon, and the petitioners who are otherwise from Delhi would intercept him at Kukumara Bridge, Chaigaon, and then threaten him. More so when there's no allegation in the FIR that the advocate of the informant and the petitioners earlier had a meeting of mind and had consented to meet at a particular place which is on a highway. So therefore, merely because an FIR was lodged in 19/12/2022, the court is unable to accept that the conditions of bail has been violated. Accordingly, the court is of the considered opinion that on the basis of materials available on record, no case is made out for custody interrogation of the petitioner. Accordingly, the interim bail granted to the petitioners by order dated 19/2 interim order. Mix with this. 73/2022 is made absolute on the same terms. Next way, it is provided that if the IO requires any specific document to be produced, specific notice be issued to the accused persons to produce the particular document. Application disposal. IA disposal. What is the IA? IA for?
I for one was for implementation. Implement of information. One was for. I just.
IA 169/2020 is for implement. Was this allowed? No.
180 is.
So 169, was it allowed?
No, it was not allowed.
Petition. Bill application. This is an application for very right. Mr. R.P. Sharma, and senior counsel, assisted by Mr. D. Doge, counsel for the petition applicant. Mr. J. Roy, senior counsel, assisted by Ms. Srinath, counsel for the petitioners in the PRS bail application, and Mr. Ajay Barwal and an APPFN for the state. Next, it is noted that during the pendency of this application for impediment, the applicant has been permitted to file his objection, and in course of hearing, the court has also heard the anonymous senior counsel for the applicant. Notwithstanding that no orders were impediment was passed. Next, accordingly, as the applicant has been heard, by considering the objection filed, this interrogatory application has not become infructuous. The second one.
For cancellation of interim bail.
Okay. Second application, the cancellation will immediately auto pass today. The interrogatory application stands closed. I'll take a break and come back.
For withdrawal.
1.
42.
Has charge been submitted in the case?
But the 42 lordship, it has come from withdrawal lordship, 42.
Withdrawal. Withdrawal. Okay.
Withdrawal.
Mr. Upon inspection, Mr. F. S.A. Bormia, learned counsel for the petitioner, seeks to withdraw this petition. Mr. R.J. Barwal and APP is present. Matters are dismissed on withdrawal.
Deeply obliged, Lordship.
Daily list item number 1, motion below.
May it please your lordship,
Yes,
439 of CRPC, I am in custody since 156 days. And lordship, this is the second bail petition. And my age is 74 years. I am in custody, your lordship, till 156 days. On page 34, they are mentioned 13/4/1949, my date of birth, your lordship. And I have annexed the medical documents also, 34B and 34A. I have faced very difficulties stayed in central.
no, but
Delhi,
you are
your lordship.
traveling with 132 packets of ganja, 2000 kgs.
Lordship, my eyes power is not so good, your lordship, according to my age, your lordship, and I have no any criminal offenses in earlier. And one police verification I have submitted on page number 35 annexer 8,
Page,
35 annexer 8, lordship. Page 35.
yes,
My lord, this search that case, lordship, so lordship may examine the scan copy of the record, lordship. Because a commercial quantity, lordship.
Lordship,
where is the previous order of bail?
lordship, my submission not
Page
completed.
20, lordship.
20. We'll take that record together.
Lordship, and page number 15 of the seizure list, your lordship, these articles are seized from the Jurabat Tiniali. Lordship, paragraph number
No, it's
2,
okay, but we are,
Plus
since the
two, where
records are
is it?
here, we'll call that.
and articles are loaded by the co-accused, namely
Uh,
Jitendra Singh. He is the driver, and I have a teaser business, your lordship.
Let the matter be listed. Today is Friday. Matter be listed on 4/4/2023, along with the records of BA 2934/2022, disposed of by order dated 10/2/2023. Okay. We'll have the records.
Lordship.
Please, your lordship. Confirm terms of the order dated 14/3, my lord. Case
Where is
case
the order?
49, my lord. Case 49. And property portion, case 52, my lord. 7 paragraph. It's honorable director of elementary to pass a reason order. And time limits prescribed in paragraph 9.
Okay. Well, Mr. K.R. Padgiri and counsel for the petitioner. Alleging non-compliance of order dated 14/3/2022, passed in IS Civil 358 of 2022, in WPC 5725 of 2021. This contempt petition has been filed under section so and so. Issue notice, returnable on so and so. Or it's petitioner shall take steps for service of notice and respond by on the respondent by registered post with AD. Next paragraph. The pendency of this contempt petition shall not be a bar for the respondent to comply with the order of this court. Dispensation.
Oblige.
Or
Yes, for lawsuits. I need some more time because lawsuit director will take instruction from the commissioner director lawsuits. Only because the bereavement of the director lawsuits has been expired 3 days back. So that's report I couldn't receive from the director lawsuit. So I need further time lawsuit.
How much time?
I think it will be after vacation, it will be better lawsuit.
Look, I could not follow what my learned friend submitted, my lord. I have not heard what has been submitted by my learned.
Oh, you're not hearing.
My lord, I am not.
Oh,
hearing.
he says that the director is in bereavement, husband is expired. So he needs time till
Yes.
view vacation.
Okay, my lord.
Okay. Mr. Abhishek Leonard, counsel for the petitioner is present. Mr. SMC Sisti Leonard, standing counsel for the
It is secondary education.
Secondary Education Department, has referred to the order dated 9/3/2023 and seeks some more time to obtain instructions on the ground that the Director of Secondary Education is in bereavement as her husband has expired. In view of the reasons assigned, the matter is adjourned today. List on 21/4.
21, yes. Apply.
So it is also provided that the pendency of this petition shall not be a bar for the concerned authorities to examine the case of the petitioner and to give their approval if the petitioner deserves such
Yes, is
consideration.
legally entitled, yes.
Obliged.
List comes also.
Apply, sir.
I think some.
Please, your lordship.
Well, today was fixed for instruction from the government, my lord.
Yes, my lord, I am directed to place instruction. And but sorry, my lord, I have not received yet any instruction from you. So let us maybe list for motion on 11th, my lord.
Just a moment. Mr. Chisti,
Yes, your lord.
in a non-government educational institution,
Yes, lordship.
the deputy
2
commissioner
years.
otherwise doesn't have power under the act to interfere with the managing committee.
But that only the circular was.
It's only the
No,
director of
that's like-
education, my lord, who will have the power to investigate into any matter.
Director.
Visitor would be the director.
Yes, lord.
Right.
This, your impugned letter is page 28. Let no action be taken till the next date.
The financial powers should be, my lord, financial operation of the finance of the school by the newly constituted income. That should be state, my lord. Actually, there are some.
No, this will not be acted upon. That is
Right,
good
right,
enough
right.
for you. But Miss P. Chakravarti and counsel for the petitioner Also heard Mr. G. Bokarial and Government Advocate appearing for. You first write Mr. SNT Chasti, learned standing also for the.
Only respond on one.
Yes, that is for the Department of
Second, so school education.
School Education, sorry, but for the Secondary Education Department. Representing respondent number 1. And Mr. G. Bokarial and the Government Advocate appearing for respondent number 2.
2 and 3.
2 and 3. So by filing this writ petition under Article 226 of the Constitution of India, the petitioner has challenged the minutes of the meeting dated
11/10/2022.
which page?
Page 28.
28. 11/10/2022. Held in the conference hall of Deputy Commissioner Kachar in connection with issue related to Silchar Collegiate School, Silchar. By the resolution adopted in the said meeting, amongst others, the all activities relating to the school was ordered to be taken up by the managing committee headed by the respondent number 3, who is an ACS officer and serving as executive magistrate, Kachar. The petitioner is also assailed the proceedings of the emergent meeting of the managing committee of the said Silchar Collegiate School held on 30/9/2022, whereby the meeting resolved to nominate a person as the president of the reconstituted managing committee by which powers are also granted to the said person in the matters of signing of checks and other financial dealings. That person is not here, respondent.
And respondent number, that person is not.
And even that reconstituted managing committee is not there. That
No.
can't be stayed. Next one. Issue notice returnable on so and so.
4 weeks.
Petition shall supply extra copies of the writ petition to the learned counsel representing the 3 respondents in course of the day. Next, having regard to the provisions of which provision?
Supervision and inspection is section 20. by the
Page
directive.
of this, which page of this book?
Page 386.
Three 86. No, this book. I'm having this book. Hold on. So what is the name of the act?
Act is Assam Non-Government Education Institution Regulation and Management Act of 2006.
2006.
Yes, which provision section?
Section 20, my lord.
21.
20 is supervision and inspection.
And here are the provisions of section 20 and 21 of the Assam non-government educational institutions within bracket regulation and management bracket closed act of 2006. The court is inclined to suspend the operation of the resolutions adopted in the meeting of in the minutes of meeting held on 11/10/2022 at 5 PM in the conference hall of Deputy Commissioner Kachar in connection with issue related to Silchar Collegiate School, Silchar. Next, in terms of order dated 15/3/2023, the learned government advocate shall obtain the instructions from the respondent number 2. List on. List out of 4 weeks.
6.
Yes.
Yes. We have challenged the impugn order. The minutes that your lordship will find at page 105. The particular portion.
Just a moment. Page
105, madam.
Yes.
Yes. This was adopted on 2/8/2022 and it was furnished on 6/1/2023 to the petitioner on the response of the RTI application.
Where is that order of 18/7/2022?
Yes. That order lordship will find at page 80. Operative part page 81. Page 81 second and third paragraph.
Yes.
Yes. Now against this The appeal is filed by the petitioner, which is pending, that your lordship will find at page 82. Page 82.
Yes, okay.
And my lord, appeal is under active consideration. Now, lordship kindly see in the meantime, my lord, certain development has been occurred, my lord, at page 84. Lordship will find. Page 84.
Yes,
Yes. Now, my lord, in between, my lord, petitioner was threatened to, my lord, terminate from his service, and he approached this honorable court. And this petition is also pending. And there is an interim order. Lordship will find at page 85.
which was the page, your appeal, rate appeal, where is that?
Not writ appeal, my lord, the appeal before the, my lord, commissioner. At page, my lord, 82. Page 82, my lord.
Okay,
Yes. Then lordship will find, my lord, the interim order passed by the honorable court at page 84. In a writ proceeding, page 84, my lord.
yes,
And operative on, my lord, page 85.
yes,
Second and third paragraph. My lord, this petition is pending. And interim order is, my lord, operating. Now, my lord, recently, my lord, there was an hearing in the office of the, my lord, Commissioner Secretary. Lordship will find at page 90.
yes,
90, my lord. There is a minute, my lord, regarding regularization of the service of the petitioner. And my lord, after that, my lord, another hearing was, my lord, held. Lordship will find at page, my lord, 94. Page 94, lordship.
yes,
Yes. It was held on, my lord, 22nd of December 2022.
yes,
Yes. Now, in between, my lord, he was absent for a particular days because of his illness, my lord. And accordingly, he filed an application for granting leave that your lordship will find 103, page 103, my lord.
yes,
Yes. Certain period, my lord, 37/22 to 3/11/2022. Now, that was also pending, my lord. And subsequently, my lord, the impugned order has been issued at page 105. Now, lordship consider, my lord, one thing, my lord, we have stated, my lord, in our petition, my lord, elaborately at page, my lord, 20, para, my lord, 28. Page 20, paragraph 28, my lord. Now, others are allowed except this petition. Why, my lord? Page, my lord, 20, para 28, my lord. We have given the name of the, my lord, is an every individual. There are 28. So, my lord, no option, my lord, petitioner before lordships. He is, my lord, 49 years.
no, but I can't do anything, negative equality can't be invoked. The first part is that this court issued a direction and the director had education, had passed an order rejecting your claim, and thereafter the managing committee took a decision not to allow you.
Yes.
That is one part. Now we'll have to demonstrate that in a non-sanctioned post where you can, we have been accommodated. It could have been otherwise dealt with by the authorities. That is the first part. Second part is that your case was taken up by the for adjudication. And therefore an order was passed. Therefore, if others are continuing, they are there by default. But negative equality, we can't permit to be invoked. So we'll only issue a notice in this case, no interim order.
Now,
This order of page 104
Malad.
will be subject to outcome of the litigation.
But since others are allowed, my lord, I am submitting, my lord, since others are allowed, my lord.
No, but you see, after rejection by the director,
Yes.
the authorities in the vertical school, they
Yes.
will not be, they will not have power to do it.
Now, since, yes, after the director's order, my lord, appeal is filed before the, my lord, commissioner and secretary. That is pending also, my lord.
Okay. We will make it subject to this
Malad.
petition or that appeal, whatever be,
My lord.
correct? By Mr. M.A. Mandar and counsel for the petitioner, as well as Mr.
Yes, that's my.
S. Das, Leonard, Standing Counsel for the Higher Education Department, appearing for responding numbers
2, 4, and 5, madam.
2, 4, and 5. For finance will be there.
I think, that one number 2.
Document number 3.
For finance is there, Mr. Nayak. Number 3,
Finance.
Yes, sir.
Mr. P. Nayak, Leonard, Standing Counsel for Finance Department, appearing for respondent number 6.
I'm for respond number 1.
And Ms. D.D. Burman, Leonard, additional senior government advocate, appearing for respondent number 1. Make it in serial order. Higher Education Department will be 2, 4, and 5. You will not be appearing for principal.
No, my lord, I'm not appearing.
Okay, next page. Agreed that the resolution number 8 dated 2/8/2022 adopted by the governing body of Howrah Ghat HABRAGHAT Mahavidyalaya, anonymously resolving not to allow the petitioner within bracket part-time on the contractual basis bracket close in the Department of English at the said college. The present petition has been filed under Article 226 of the Constitution of India. The learned counsel for the petitioner has referred to the order passed by the Director of Higher Education, Assam, on 18/7/2022, and it is submitted that that against the said order, an appeal has been preferred before the Commissioner Secretary to the Government of Assam, Higher Education Department, which is pending. It was submitted that during the pendency of the said appeal, the service of the petitioner was terminated, while similarly other situated persons are allowed to serve in the said college. Expedition notice written on the ground so. Or it's requisite extra copies of the petition they served on the United State and Departmental Council appearing for the respondent numbers 1 to 5. So the petitioner shall take steps within 2 days for service of make it 3 working days for service of notice on respondent numbers 6 to 8 by registered file with AD. Option is given to the petitioner to serve notice on the said respondent by way of the state by routing the process through the registry of the court and to file an affidavit of service if such a step is taken. Next one. Having regard to the projection made by the learned counsel for the petitioner. Court is inclined to provide that the hearing before referred. The impugned resolution number 8 dated 2/8/2022 adopted by the governing body of Abragat Mahavidyalaya shall be subject to further orders that may be passed in this either in this writ petition or in an appeal filed by the petitioner before the Commissioner Secretary to the Government of Assam Higher Education Department. Please start, please. Mr. Mandar, I'm just asking you because for certain reasons, you are satisfied with this, or you want other refusing you interim relief?
No, Mulata, not only Mulata, being Mulata, sees Mulata 49 years of age as on date. He has no Mulata future. He has devoted Mulata 17 years in that particular college. Mulata. Now, where she will go, he will go, Mulata. 17 years. Mulata.
I understand that.
And recently, Mulata, the government has taken decision to regularize those contractual teachers. I have some Mulata information in my Mulata website, Mulata. I will bring it on record by filing additional affidavit, Mulata. There was a development.
Okay.
For this type of Mulata gentlemen.
People, okay.
Yes.
Okay. That is good if it happens.
Mulata. Develop.
Item number 7.
Yes.
Matter relating to temporary loss of the headmaster upper primary school. The school was provincialized under the Act 2011, which was already set aside by this honorable High Court member. And along with the other teachers, the petitioner post was sanctioned. But due to interim order of this honorable High Court, post was not provincialized. Later on, his post was provincialized. That is, your lordship will find page 17 annexure A. On 17 November 2014, his post was provincialized as the assistant teacher. Thereafter, the traditional list was published by the BO, concerned BO, that is, your lordship will find page 21.
Mr. Islam, just tell me, I found it somewhere that the respondent is joined before you.
No, my lord, that is initial stage, my lord. Dancer period, my lord. And as well as the dancer period, as well as the in provincialized school, but the date of effect of provincialization is same. That is 1/13.
You can only issue a notice at this stage.
My lord,
No, my
You
lord.
can't grant an interim order.
My lord, kindly see
Yes,
the
my lord. He has gone
improved
later.
order, my lord. Matter already referred to the higher authority. My lord, in this interim order, improved order,
Page
my lord, 30, my lord. Page 30,
30.
my lord.
Yes.
Yes, my lord. Your lordships will find decision, my lord, in bottom, my lord,
Yes.
last one.
Respondent was allowed to
Yes, my lord.
temporary charge.
Yes, my lord.
Yes.
Above this, my lord. Thus, it appears that this is a complex issue which requires to further clarification from the higher authority.
Yes.
My lord, since, my lord, the in charge was given to the petitioner earlier, my lord, as well as the DO, my lord, and without taking the clarification from the higher authority and deciding the seniority, why the charge was given to the junior teacher, my lord. Your lordship will find, my lord, order, my lord, page 24, my lord. Charge was given to the DO as well as the petitioner, my lord. And the matter, seniority matter, has been referred to the higher authority, and without deciding the seniority and without taking the clarification, why the charge was given to other teachers, my lord. Your lordship will kindly see the page 24, my lord. D was given the charge to look into the all the matters of the school, and petitioner was given the charge to academic side. And issue of seniority has come between the petitioner and respondent number 6. And why she is Harry, my lord, DO, my lord, without deciding the same, my lord. Period of Benser, my lord. Benser period will not be counted for determination of the seniority, my lord. This is the stance of the government, my lord. And provincialization, petitioner provincialized was later on, but date of effect is same, my lord, 1/1/13, my lord, 2013, my lord. So petitioner is the senior. His petitioner date of birth is earlier than the respondent number 6, my lord.
What is
That is the word whereby matter was referred to the director, my lord.
no, but there is a reason assigned in that order. That you joined later, he joined earlier.
In provincial assessment, my lord.
Yes.
My lord. Yes, my lord, that is correct, my lord. But post was allotted at the time of the allotment of the post of the respondent.
Maybe, but joining is earlier.
Joining is earlier, my lord. Date of effect of provincialization is same, my lord.
Maybe, but there is a reason assigned. We are not disturbing it right now. But I'm issuing a notice on the prayer of my interview.
My lord.
And my lord, I have received one instruction, my lord, regarding seniority of teachers of OST, Hanapuya, Noria, Emi Madrasa, my lord. One hearing was done, my lord. So, one speaking order also passed. So, my lord, I have to.
My humble submission is that till the clarification come from the director, my lord, improved order may be stimulated.
No, my lord. Already hearing was done, my lord. As per
Let
that
them give
order.
the instruction, my lord, if hearing is completed.
Same thing. You'll have to remove this DEO. He appears to be incompetent.
My lord.
Your DEO appears to be incompetent. Just think what will happen. I hear your case, correct? Then I write a letter to some other judge saying that please advise me what to do. So why should I take up a hearing if I can't handle it?
Yes.
He's incompetent. We'll have to record this. DEO is incompetent. Let his assessment be made first. He hears the matter.
Yes.
Then he writes to the director, please advise me what to do. Can he do it? Right.
Yes.
And charge already been given.
Gives charge to
Nothing
somebody
is,
else.
nothing is given here.
Doesn't know what to do. He writes to higher authorities that I am hearing a matter, please advise me what to do. Then I will stay it.
Yes, sir.
He can't be like that. We'll ask the commissioner secretary to handle this matter.
Same officer, earlier charge was given to petitioner, my lord. Earlier. my lord.
Where is that?
Page number 24, my lord. Last line, my lord.
Same DEO.
Academic
If
cycle.
he can't handle the matter, he should give it to the higher authorities.
My lord.
But now he receives a restriction from the
I
court.
have received that instruction from the petitioner.
No, whatever be,
My lord.
what you see, there's a difficulty when you producing something which is you obtained from him. You'll have to take it that you have produced it, knowing you are taking responsibility in producing it. If it is not yours, you did not produce it. Nobody asked you to produce a document which is being given to you by the counsel for the petitioner. But now you are inviting a stricture. This man will be in trouble now. Heard
R. Islam.
Mr. R. Islam, the counsel for the petitioner.
My lord, let the matter may be handled by the director or
No,
commissioner.
let the commissioner do it.
My lord.
Why director? Even director may not know what to do. Then he will write to a commissioner. Commissioner will write to the governor. Even if he can't take a decision, so you refer it to the commissioner, let him take a decision. If he wants, he'll ask the governor to do it. This is not how he handles the office. Mr. Mazumdar, this officer is in trouble.
Hello?
At the motion stage, this officer is in trouble. You look what he is doing. You have seen this letter. This officer is in deep trouble at the motion stage.
It may be petitioner move this one. Leave this one.
Let me tell you what has happened. Mr. Mazumdar,
My lord.
just to make it time to save time. This officer, DEO, first appoints Mr. Islam as the in charge principal. Then he again takes he's hearing a matter. He calls both of them produce documents. Now he arrives at a decision that date of what you call the provincialization is same. The date of effect of provincialization for both of them are same. The private respondent joined earlier, he joined later. So therefore, the private respondent is made the headmaster in charge now. And no, not even that. The most interesting part for which I am amused is that now he writes that I have taken a hearing on 13th. Now, dear Mr. Director, please advise me what to do. As if the director has no other business but to advise him how to run his office. Now he's in trouble. This advice first will ask the commissioner to give it to him, not the director. We restrain the director from exercising that power. Let the commissioner give him the advice. If he can't run the office, he must be given advice where to sit, what work to do. We'll have his competence assessed at the motion stage. Pardon me? I'm not hearing you.
The in charge is usually given by the director's office. So on immediate.
Then why should I get hearing? What is the fun? I hear your case. Just tell me, Mr. Mazumdar, how do you like it that I hear your case? Then I say that no, I'll take advice from a second judge. Then I should have recused myself if I can't handle a hearing. It's not that I can handle every case. At times I may find it very difficult to handle a matter. Mr. Nair, how is Mr. Roy now?
My lord, he is now stable. He has been taken to international hospital. Pressure had gone up, my lord. It was, I think he had a mild stroke also. One lower was, my lord, 120. Sugar was 400 something. And see, it was Roida. That's why, my lord, he was here.
I thought that because of my joke, he became.
No, my lord. I was told that from morning only he was not keeping well.
Okay.
They were not being able.
I provoked him. I now feel sorry.
No, but it's not that.
He was arguing, and I gave an example that let us assume that monthly income of yearly income of Mr. Ameshek is 1 crore rupees as professional income. And then the police investigates because he suspects that it is 2 crore. Only thereafter his pressure goes.
Right now, no effect on him. No effect on him. He is like that. What to do?
No.
He is extreme in everything. That's the problem.
No,
anyway,
because,
he's okay now.
Well, that is that you remember that Reign Supreme. Why is his white more than
more than me? Anyway, he's safe now. No, that's better.
No, that is okay. But I was feeling sorry.
No, my lord, did not. He had that when he started off, my lord.
Okay.
He might have been somewhere else yesterday night. Today morning, he might have come into Guwahati, my lord.
Okay.
Maybe that's also the reason.
Okay, I'm so sorry that. I was thinking
So for this letter is concerned, what I find is that as an interim measure, he has allowed one Abdul Jalil Sarkar to hold the charge temporarily. Now, further to this, what requires to be done is the advice is asking for from the director.
Why changes status if it doesn't know how to handle?
He has given it because again this seniority issue will go up to the director. He puts in his matter that this is what has happened. I have allowed him to hold temporarily.
No, then he would have packed the file and send it for decision. He can't sit over and ask advice running the office, what to do, what not to do. Just think, I'm managing the court here. And my court master runs and comes to me that, well, this file, what should I do? Should I send it to the section? My secretary comes that you have given me a dictation. Should I write? Should I transcribe? The second court master comes that that your video is open. Now, please advise me, should I close it? My peon comes running. Oh, this file is to be taken to the section. Should I take it? Next, by the petitioner projects that by an order dated 25/1/2023, the no, where is that order appointing you as principal? Where is that?
It's number 24.
24.
Yes.
By
Inserts headmaster.
okay, by an order under memo dated 25/1/2023, the district elementary education officer within Packet in charge I will noted that the Khas Khamar KHASH Khamar KHAMAR ME school was running without an headmaster who had expired on 22/12/2022. Khamar had appointed Khamar assistant teacher
Secondary also.
No, no, my headmaster for the same. Headmaster.
Elementary.
assistant teacher of polyest POYESTI Chalakura CHALAKURA ME Madrasa and Sri Paban Kumar Deta, assistant teacher of Khas Khamar ME school, to look after the academic side of their respective school.
Service rule.
Revision contract will be signed, sir.
Service conduct service rule.
Revision contract will be 1977.
It is submitted by the counsel for the petitioner that accordingly the petitioner started functioning as the in charge headmaster of Khash. আমরা Khamar KHAMAR ME school. Thereafter, by another order dated 24/3/2023, the DEO Dhuri had appointed the petitioner as temporarily as DDO to draw and disburse the monthly salaries of the teaching and non-teaching staff and other financial works of the school as in charge headmaster, in addition to his normal duties.
One is another order.
Now, what is his judgment? 12/6. What is this for? Right. What is his judgment of 26? This 12/6/2020, page 33 is for,
Yes, my lord.
why is this for?
My lord, the period of the bencher stage will not be counted at the time of determination of seniority.
Yes, yes, then
Seniority in venture stage.
Yes, will not be counted. That is space, my lord, 35, paragraph 11. my lord.
Okay. Thereafter, the DEO Dhruvi had passed an order dated, impugn order dated 24/3/2023, by which it is recorded that the claims and counterclaims for the temporary charge of headmaster of Poly SP Chalakura
Nuria.
Could not have decided. Why is it? Let it depend. In case of any dispute, the director of elementary education shall determine the seniors and the basics of the government should be conducting conference.
Police Chalakuria Nuria, ME Madrasa. This name you will find at page 31. ME Madrasa, hearing was held on 13/3/2023. Yes, sir. Instead order it is recorded that the service of the petitioner as well as respondent number 6, Abdul Jalil Sarkar, was provincialized with effect from 1/1/2013 as per order of provincialization dated 17/11/2014 and 19/12/2013. Oh, sorry, one is one is the Alauddin Sheikh, petitioner is on, provincial is on 17/11/2014.
Yes.
Abdul Jalil Sarkar, respondent number 6, his service was provincialized with effect from 1/1/2013.
Yes.
Right, provincial provincialization order dated 19/11/2013.
Yes.
So while the petitioner joined service on 21/11/2014, or the respondent was 6, had joined on 23/12/2013. And accordingly, we found that the issue was a complex issue which requires clarification from the higher authority, taking into consideration the date of joining, the respondent number 6 was appointed as the interim headmaster till a regular headmaster is posted or till final disposal of the issue by a higher authority. Accordingly, the order dated 24/3/2023 is assumed in this revision following Article 226 of the Constitution of India. Issue notice of motion returnable on. So we give a fixed date after 4 weeks. The petitioner shall take steps for service of notice on the respondent number 6 by registered post with AD. This treasury officer who will be appear for them, treasury officer is finance.
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 P9 was here.
Okay. Mr. P9, Leonard standing also for the Finance Department accepts notice on behalf of the Treasury Officer, the bracket respondent number 5. So according to extra copies of the requisition, they served on him in course of the petition shall take steps within 2 days for service of 2 working days for service of notice on respondent number 6 by registered post with AD. Notice is made returnable and so and so. So in addition, the petitioner shall serve notice on the respondent number 6 by way of this by routing the process through the registry of the court. And upon service and affidavit of service will be filed prior to the register of listing. Next paragraph. Having noted that the district elementary education officer Dhubri within bracket respondent number 3 has taken up the adjudication regarding appointment of in charge principal, headmaster of Polyesti Chalakura Nuria ME Madrasa, found the issue complex and has sought for clarification from the higher authority. Full stop. The court is amused by the fact that the DEO, after seeking advice from the higher authorities, is expecting a clarification from the higher authority. The court is also amused by the fact that having taken up the adjudication of whom to be placed as temporary in charge headmaster of the said madrasa, finds that he cannot handle the matter and requires clarification from the higher authority to take a decision. Nonetheless, he disturbs the position of but the said authority disturbs the position of the petitioner and appoints the respondent number 6 as in charge headmaster. Full stop. It is also noted from the documents produced by the petitioner within bracket Annexure B, which is a gradation based property signed by the block elementary education officer, wherein the date of getting of scale of pay by both the petitioner and the respondent number 6 is indicated as 1/1/2013.
Date of birth also can be similar.
And so far as the date of birth is concerned, the petitioner is senior to the
Yes.
respondent number 6. Therefore, the basis on which the distinction is made between the two on the basis of date of joining provincial service does not have any clarity. Next paragraph. As the appointment of officers, this district elementary officer, education officer, his appointing authority is the commissioner.
Yes.
Is the appointing officer of the district elementary officer is the commissioner and secretary to the government of Assam. my elementary education department. Having noted that the DEO Dhubri requires clarification from the higher authorities, it would be appropriate that the file relating to the matter where clarification is sought for by the district elementary education officer, we also processed by the, we also inspected by the Commissioner and Secretary to the Government of Assam Higher Education Department. As it appears that the DEO has washed off his hands to take a decision unless he receives clarification on the higher authority. Next, the court does not doubt the submissions made by the learned standing counsel for the elementary education department that the issue relating to appointment of headmaster has to be settled by the district, director of elementary education of Assam. But here is a case where the DEO is unable to handle his handle the hearing without an advice or clarification from the higher authority. It is in the said context that the court desires that the Commissioner Secretary to the Government of Assam, Elementary Education Department, be also asked to peruse the records. To stop. Needless to say that it will be open to the Director of Elementary Education at Assam to carry on advising his subordinate officers how to handle the hearings, if he so desires. Next, having noted that despite finding the issue complex, which requires clarification from the higher authority, the DEO has disturbed the position of the petitioner, and the court is inclined to stay that part of the impugn order under memo number so and so, page 30, dated 24/3/2023. Insofar as
it's next order also. That financial service.
Insofar it is to allow the respondent number 6, namely Abdul Jalil Sarkar, to hold temporary charge of headmaster of Polyst Chalapura Nuria ME Madrasa. So the consequential order,
Yes.
the impugn order dated under memo number so and so, page 31, dated 24/3/2023 by the district elementary officer, will also remain state till the next date of listing. Next, it is provided that the interim order, the extension of the interim order beyond the next date shall be subject to the instructions which is received by the learned standing counsel for the elementary education department. List on Spencer. Nothing, if it's not, as per advice, I have not done it. I was refusing to give a stay.
What are these 1981 rules makes the director the concerned authority to determine seniority?
No, I understand, but then he washes off his hand.
Yes.
He
should have done
cannot,
it completely.
he cannot take up the adjudication and
Yes,
then
he
say
should
that
not.
you are the authority to
Yes,
decide.
That matter, I'm not just the position that the director of elementary
It was-
education
it
decides.
was amount to disregard of the authority. I can't take up a issue which I am not authorized. And then tell the superior officers or superior authorities, please advise me what to do. These people only for that reason.
One for the
And I would like to withdraw this matter.
Okay.
Yes.
Upon instruction, Mr. HR Chaudhary and counsel for the petitioner seeks to withdraw this petition.
The liberty to file a fresh if necessity arise, my lord.
Okay. Liberty to approach again if necessity arises. First up, the secondary education. Mr. R. Mazumdar and his technical for secondary education department. And Mr. G. Bokale, the government advocate, is present.
Published.
daily list item number 8.
Yes.
Take up the cases that my lord petitioner were appointed against my lord sanction post at Lower Primary School under Mongol subdivision.
BTC council requirement. Mr. Nayak is here. I will just call him.
Okay, okay.
Year 2001, my lord.
Just wait for some time.
Yes. Sir.
Nine. Item
No,
number
item 9 is already John. Number 10.
10.
May I please, your lordship?
Yes.
The petitioner is the science teacher, lordship. My senior is on legs.
Okay, you are appearing for
RM Das.
RM Das. Okay, after some time.
After some.
11.
I'll issue a notice here. None appears on call for the petitioner. Oh. Oh, you're
Yeah,
there?
please, your lordship.
Okay, I'll issue a notice in this matter.
Lordship, lordship.
Ms. G. Bora and counsel for the petitioner. Mr. G. Bokale and government advocate appearing for respondent number 1. And A. Fukan Leonard, 1 and 5. And say A. Fukan Leonard, standing counsel for the elementary education department. Appearing for the remaining respondents. In view of the nature of grievance raised in this petition, issue notice of motion returnable on so and so for 4 weeks. Requisite extra copies of the writ petition be served on the Leonard State and Departmental Council in course of the day. List on so and so.
Finance department, I think is also there.
Finance is also there.
Yes, respond number 3.
Okay, finance, Mr. P. Nayak, understanding counsel for finance, appearing for respondent number 3. Okay.
Keep your lordship.
Item number 10.
May I please, your lordship? Petitioner is a science teacher. He was a science teacher, lordship, in a high school, lordship. Thereafter, on show cause notice was served upon him. Thereafter, he was suspended, lordship. After
I
some
can issue only a notice at this stage.
Lordship.
2008 matter.
Lordship,
And what is the explanation of coming now?
Lordship, he was not well, Lordship. I have annexed some documents regarding his medical status.
Yes, what is that medical?
Medical Lordship, page number, Lordship, connection number 9 and onwards, Lordship. And he was also in financial crisis, Lordship. Simple subsistence allowance was also not paid to him, Lordship. During his suspended period, Lordship.
Oh, you see, I was thinking 2018 while I'm issuing notice. 2008, I
Yes,
skipped my
Lordship.
mind. 2008 is 15 years now.
Lordship. Annexion 924 onwards, I have annexed some certificates showing it was not well, and the Lordship, the financial condition was not that to approach Lordship. At least subsistence allowance during his suspended period, that is his legitimate expectation, Lordship.
Lordship, regarding that.
Because Mr. Kango,
Lordship.
insofar as your prayer for this reinstatement is concerned,
Yes, Lordship.
that I'll be rejecting.
Lordship.
But insofar as your subsistence allowance
Yes,
is there,
yes,
I
Lordship.
issue notice on that.
Yes,
Lordship, notice may be issued at this stage, Lordship, because regarding the prayer which the petitioner has made regarding his subsistence allowance, that order has been passed in the year 2005 itself, Lordship. I have the copy of that order, Lordship. And a copy of that order has already been furnished to the petitioner also, but that order he has not challenged, Lordship. Where he has been reinstated in his service.
Yes,
Lordship, the thing is that petitioner many times he's been absent, remain absent, without intimating the concerned authorities. Many times locus notices were also issued. All these are,
Yes, Lordship. He was ultimately
and
discharged
he
from the
himself has
service.
admitted, Lordship.
Yes, discharged from the service
Now you are
because
reinstated. That's
No.
what he says.
Although he has been
I
reinstated
reinstated, I
That
have
is-
fixed that order, Lordship.
in November
Lordship, kindly
2000,
see
17
page
November
number-
2005, Lordship.
Lordship, page number 16, reinstatement order.
15,
Page number 16, type copy
16.
16, annexure 4, Lordship. The reinstatement was done with some terms and conditions, Lordship. And in that
That order has
condition,
not been challenged, Lord.
I was transferred to a school of NC Hills, Lordship, where I could not join, Lordship, and I made a prayer for some other arrangement, Lordship.
No,
That proposal was also, Lordship, that was also forwarded by Director of Secondary Education, Lordship, page number 1920 to the, Director, IAS Director to the IA Commissioner, Lordship, regarding my transfer to Karimganj district, because I could not join in the NC Hills, Lordship.
Okay.
This process was going on to accommodate me, Lordship. In the meantime, they have discharged me. My prayer that
He has
during the
already joined in that.
suspension period, I was not paid subsistence allowance also,
Okay, but the reinstatement that we are refusing.
Lordship. At least
They have
subsistence
not
allowance.
challenged that order, Lordship. The order which has passed on 17 November 2005 has not been challenged by the petitioner.
Okay, That's
Now
why we
they-
are refusing that. First period we are refusing. But we as Kanugol and counsel for the petitioner. And Mr. R.M. Das, learned pending counsel for the NCL's Autonomous Council, appealing for respondent numbers
3 and 4.
3 and 4. Secondary education. R. Mazumdar, and standing counsel for secondary education, representing respondent numbers 1 and 2. Next para.
Somebody say, please name me.
The case of the petitioner is that he was put under suspension by order dated 29/7/2004,
1, 2.
passed by the Inspector of Schools Haflong, but later on reinstated by order dated 17/1/2000, 17/11/2005.
5.
Which was a conditional order by which the petitioner was transferred and posted to Lysong, LAISONG High School.
What a reason.
Within the jurisdiction of NCL's Autonomous Council. First of all, the petitioner claims that for ill health, he was on a disability and could not join service. And in the meanwhile, the service of the petitioner was discharged from service by order dated 15/3/2008. The learned counsel of the petitioner submits that the petitioner has made a claim for payment of subsistence allowance during the period he was under suspension. And it is submitted that in view of the illness, the petitioner could not join. Earlier in point of time, next paragraph. It should, having noted that the petitioner was transferred by order dated 17/11/2005, which was not challenged. And further considering that the discharge of the petitioner by order dated 13/3/2008 within bracket Annexure 7, issued by the Inspector of Schools Haflong, are not under challenge. Insofar as the prayer number 1 of this petition is concerned, whereby the petitioner is prayed for a direction upon the respondent authorities to reinstate him in service as science graduate teacher in high school in the state of Assam, is rejected at the motion stage without issuance of notice on the respondents. Also, insofar as the prayer for subsistence allowance during this period, suspension period is concerned, let a notice returnable on so and so be issued. Give a fixed date after 6 weeks. The petitioner shall serve requisite extra copies of the petition to the learned departmental counseling within 2 days. Next paragraph, the petition of the petition shall not be a bar for the Inspector of Schools, Karbianglong Haflong. Sorry, Dimahasa Autonomous Council Haflong to examine the claim of the petitioner for subsistence allowance and pass appropriate orders for the purpose of releasing the subsistence allowance during the suspension period of the petitioner from 29/7/2004 to till issuance of the reinstatement order dated 17/11/2005. Next, list on so and so.
15/5.
You see that the authorities whatever possess that part at least. Oh, your paper, Mr. Das.
Lordship. All the time petitioner is totally irregular, Lordship. Although he has been suspended, later on reinstated. In a new school also, he has been irregular.
It can't be helped. People have their difficulties.
Deeply.
Yes.
The petitioner were appointed under my lord BSc authority, my lord, in 2001, my lord, in OBV scheme, my lord. Then my lord, in 2003, my lord, BTC government, BTC was formed, my lord. Then my lord, one respondent number 3, my lord, issued termination letter, my lord, to the petitioners, my lord. That my lord, they have filed, my lord, before this honorable court a case, my lord, with petition, my lord.
I'll issue a notice at this stage
Lordship.
in this matter. Good. Mr. M. Kalita, land counsel for the petitioner. From Mr. Elementary, you are appearing.
Secondary, my lord.
This is elementary item.
Yes, elementary.
LP school. You'll be there. You'll be there. Miss P. Fukan.
My name is N. Fukan.
And Fukan, I'm sorry. I always forget. I'm forgetful. Sorry. And Fukan Leonard, standing counsel for the Elementary Education Department. Appearing for respondent numbers.
1,
2,
Secretary Education.
3,
2, 3, 4.
4. Okay.
2, 3, 4.
2, 3, 4. For Mr. Ardhar, Leonard, standing counsel for WPC and DC Department, appearing for respondent of 5 and 6. And Mr. P. Nayak Leonard, standing counsel for the BTC, appearing for respondent numbers 7 to 12.
7 to 12.
In view of the nature of grievance raised in this present petition, issue notice of motion returnable in 4 weeks. Requisite extra copies of the petition with served on the State and Department Council in person within 2 days. Distance so and so. List for 4 weeks. You'll be able to get instructions by then. 4 weeks, you'll be able to get it.
Lordship, I should get. Lordship, it's a case of 2001, Lordship.
I understand. That's what I'm asking you.
And the phrase process was started only in the year 2020. That is also within the realm of BTC authority itself. It was never forwarded to the finance department. So I will get instruction, Lordship, but it's just.
No, it's just an old matter. That's what I'm asking you. Within 4 weeks, you'll get it.
Lordship.
Okay.
Well,
May I please, your lordship. Regarding compassionate appointment, your lordship. Petitioner's father was a grade 4 employee who died on 25/3/2013 while he is in service. Then the petitioner applied for compassionate appointment on 5/4/2013.
You see, the full bench says that after the period prescribed, the matter is deemed to be rejected. We are bound by it. How can we disregard the?
Lordship, it is not placed till date.
No, even if it is not placed, it becomes lapsed by virtue of that
Lordship, the coordinate bench of this honorable court has held that
Now, how
it
do
is,
you over?
it is incumbent upon the respondent authorities to place any application.
No, you see, by now, this scheme has also changed. The second part is that how do you overcome the decision in this what do you call, Achyut Ranjan Das? How do you overcome that? Even if it is not placed, it deemed to be lapsed. It has spent its force. That is the language used. How do you overcome that?
Lordship, as per the Achyut Ranjan Das, within 2 years, if the application has been considered and not has been placed and not been considered due to want of vacancy, that only it will not become after 2 years. But in this case, the application has not been placed till date.
Where is the vacancy of that time?
Lordship,
Where is the existing vacancy of that time? 2013. Will it be vacant till now?
Lordship, can come to page 19, your Lordship.
19. I'm there.
And the last line in this connection, it may be stated here that a post of grade 4 is lying vacant in Bhoskwa Sapuri Senior Madrasa in the district of Sunil. Lordship may direct the respondent and place it before the DLC and consider it on its merit.
You see, in your application, please come to page 24.
Lordship,
Principle 10.
Lordship,
Please read that.
Lordship,
Principle 10. Please read that.
if the application of eligible candidates remain pending and can be considered due to want of vacancies for a period of 2 years from the date of making such application, will require no further consideration and must be understood to have spent their force. Want of vacancy. Here it is written that want of vacancy. Fellowship coordinator says it is incumbent upon the respondent to place the paragraph 3, your Lordship. The law in this aspect has been settled by this court in it is held that it is incumbent upon the respondent authority to place any application for compassionate appointment before the concerned dates. My case has not been dealt with. A direction may be given, your Lordship, to place it before the DLC and consider it as per law.
Mr.
P. Ram.
P. Rahman, going to the petitioner. The case of the petitioner is that his father was a grade 4 employee of Bhojpur Chapuri Senior Madrasa, BHOJ KHOWA Chapuri CHAPARI Senior Madrasa, who died in harness on 25/3/2012. The petitioner applied for compassionate appointment on 5/4/2013. So it is claimed that till date, the application of the petitioner has not been placed for consideration before the district level committee. First off, it is also projected that the education department had directed DLC meeting to be convened for considering pending cases for incumbents who died on or before 31/3/2017. And it is projected that the case of the petitioner was not placed. Next one. Referring to the order dated 29/1/2018 passed by this court in WPC 364 of 2018. However, the learned counsel for the petitioner submits that it was incumbent upon the respondent authorities to place the application of the petitioner for compassionate appointment before the concerned DLC. Issue notice of motion returnable on so and so.
4 weeks.
Secondary education, you will be appearing. Miss
It's there.
H. Therapy, learned standing counsel for secondary education department. Accepts notice for respondent numbers 1 to 4, 1, 2, and 4. And Mr. G. Vokalia, learned government advocate, who accepts notice on behalf of respondent 3. Extra copies of the notification will be served on them within 2 days. Next one, the pendency of this petition shall not be a bar for the concerned authorities in the secondary education department to examine if the case of the petitioner was ever placed before the DLC, and if not, the claim of the petitioner for consideration for compassionate appointment shall be placed before the concerned DLC. Sonitpur. For a decision on the petitioner's claim. Next slide, list on so and so.
I love it.
13.
Just a moment. The petitioner shall produce a certificate copy of this order before the inspector of schools within like a respondent of 4. Enabling to do the needful.
My lord, there are two matters, item number 13 and item number 43 are analogous, my lord, same issue. My lord can have that file of 43. No? Amit Hassan Mojumdar. My lord, this pertains to a recruitment process in the Ayurvedic Government Ayurvedic College, my lord, Guwahati.
Yes.
My lord will have page 18 of that 43, item number 43.
Okay.
My lord, in the year 2021, 12/7/21.
Just have a look at the impugn order first.
My lord, there is no impugn order, there is an advertisement, my lord, which my lord would find at page 37. 37. My lord, I am for my lord serial number 11. Sanskrit Samhita and Siddhanta.
In both the cases.
In the other case, my lord, it's serial number 7, Roga Nidhan. My lord would see both these posts have been reserved for OBC and MOBC. Whereas the petitioner in my lord Roga Nidhan is an SC, and the petitioners in Sanskrit Samhita and Siddhanta, they are general candidates. I'll show my lord how this error has come to. If I can just tell my lord what happened. My lord, in the college, there is no roster. There was no roster. What they used to do, my lord, till this exercise, they used to treat all the, my lord, assistant professors or associate professors as one cadre in the whole college, and thereafter work out the, my lord, roster point. and they used to go ahead and do that. But there was no roster register. Then, my lord, when this advertisement, draft advertisement at page 18 was issued, reserving the post of Samita for, my lord, the OBC committee, we took up the matter with the government. Our case was, my lord, either you go for the whole thing, prepare a roster and do it. And if you're going department-wise, then it will be a different ballgame because the post will come down. Now, in this department, my lord, of Sanskrit, Siddhanta and all, there are 5 posts only. So you can't have that whole register, roster register applied. There is a 13-point register there. This matter was inquired, this matter was looked into by a committee. The committee also came to this conclusion. Thereafter, it went to the Director Ayush. Director Ayush, my lord, the committee said 4 posts. Director Ayush clarified the position and said there are 5 posts. And thereafter, my lord, the matter was again processed, and the decision was that the draft advertisement was issued, saying that this post will be advertised as unreserved. But surprisingly, when the advertisement came out from the medical and, my lord, health board, they have a board now, my lord, it was advertised as OBC. Now, I'll demonstrate before my lord that either way, it cannot be done. Because if you are going by the 13-point roster, my lord, which they have applied, I don't subscribe, but anyway, they have applied that. Then, my lord, if it is 5.5 posts, then 1 post, according to that, will be rotated amongst various categories. That's there in the rules, my lord. If that is to be done, this is the first time they are doing it, then, my lord, it will be an unreserved post. Similarly, in the other case, my lord, that cadre consists of 2 posts, my lord. One, a UR is already there. They are putting a, my lord, OBC to them. Now, OBC percentage is 27, my lord. If my lord applies that, then if it is out of 2, you are giving 1, the percentage of reservation goes up to 50. Supreme Court has said that is not permissible. You can't go beyond the quota. In this view of the matter, and the second case, my lord, the irony is this post, this department, my lord, they wanted to start a, my lord.
So you are trying to say that since it can't be 50%, therefore the entire cadre has to be taken into account.
My lord, I'll say that if you are going by the department-wise, cadre-wise, then you apply the 13-point roster, then also you can't reserve it for OBC. Or you will have to factor in all the posts which have been filled up. If that be so, my lord, in this case, in item number 43, there are 2 OBCs already there who have been there and then gone up. So you go forward. I'll show that, my lord, 13-point roster. You go forward. Every community gets a representation. Now you are only sticking to OBC because there is a pressure. And you have people who are there, my lord. So they want to bring them. And the principal had put up the draft advertisement saying it will be unreserved. After, my lord, the Director Ayush and that committee had done it. Now the problem here is this advertisement was issued on 16th, my lord. Last date was 31st, today. But till today, my lord, the portal has not opened. So what they have done, my lord, they have extended it till 14/4. Till 14/4, but still the portal is not open. NHM portal they are doing it, it's not open till. My only limited prayer at this point, because, my lord, this matter requires to be examined. My limited prayer is, my lord, let us also submit our applications, because tomorrow they are not going to hold this election. Let us submit our applications. Let my friend have his instructions, my lord. My lord will fix the matter, and for my lord may hear the matter and my lord finish it. Or my lord finally pass some orders, my lord. This is my only prayer I can make at this point of time, my lord. And my lord, the other case, that man, he was an officer, a medical officer in the health and family welfare. They wanted to start a PG course. They had no PG qualified candidate. So, my lord, he was brought from there and posted here in the college. And then his name was given to CC, because now, my lord, these things are controlled by the central government. There is a body, CCIM. They gave him a code, my lord, that for them, he is a teacher. Now that post has also been, because he's working there for nearly now, my lord, nearly 10 years, my lord. Now there are letters which says that kindly advertise it in a manner that he can also apply. Now the application OBC, he's an SC. Even if it is general, my lord, he could have applied. Now he is also ousted from the field, my lord, after taking his service for 10 years. Not 10 years, it's around 9 years now, almost 10 years. This is my grievance. Only limited prayer before my lord. Let us submit our applications. My lord, that would be, my lord would decide the matter before the recruitment process. Because there admittedly, my lord, I can show from the record, there is nothing. My lord. Till the last election, it was, my lord, or the whole college as one. Now they have changed it, my lord. If your lordship wants an immediate observation on that, my lord may come to
No,
page 32.
I won't text myself if I'm to hear from some other day.
This is the case, my lord. If they can demonstrate, my lord, that even by applying either of the two criterias, OBC will only come in, fine, my lord. I have nothing to say. But I can demonstrate before my lord from the 13-point roster, because they say it's a cadre below 13 posts. So they have gone to that roster. It cannot be. If you're operating it for the first time, then it will be the first initial recruitment. It will be a new one. 5 posts, my lord. And if it is 2 posts,
My lord, or I may obtain instruction, my lord, because last date is 14 and the portal is not open because subsequently, my lord, a corrigendum has been issued. So let me have obtained instruction. Your lordship may take up in the next week. In the
because next week only fear, my lord, is that because of the
Next week
function,
may-
it will not be possible, my
It will
lord.
not be possible. I'm issuing a notice.
Lordship.
uh,
Let them file their affidavits, my lord. We'll be, my lord. And only thing, my lord,
This for that 13-point roster, you are referring to page.
my lord, 300, my lord. It's that, yes, my lord.
37, okay.
They are saying it's, my lord, will come to,
First page is UR.
my lord, 20. It's UR. And I can show that, my lord, if it's a 5-post cadre, in the first post is, my lord, UR, second is UR, third should be SC, fourth would be OBC, UR, then UR, then, my lord, it's a 7-post OBC, SC, ST. It's at page 300 of the, my lord.
Actually, my lord, the college, while assessing the, my lord, reservation, they took all the posts as a whole,
No,
not
no.
department-wise.
No. Department wise.
No, just a moment. The 13-point roster.
Lordship. My lord would find it at the Assam Services Manual. Page 300.
Page 300.
300. Blue book. Of that, my lord, it might be different. It's appended to the Act, my lord.
Which act?
My lord, the Assam Scheduled Castes and Scheduled Tribes Reservation of Vacancy and Services in Post Act 1978, my lord.
It was an 8.
No, my lord, 78, 1978.
78.
Lordship.
Okay.
Page 300, my lord, it will be in the last page of that act. Then the rules start.
It's 100-point roster here.
My lord?
100-point roster.
No, my lord, there is a 13-point roster. Maybe it has not come in that book, my lord.
No, just give that. 13 is not there.
No, my lord, maybe after that, this is the latest. Says, my lord, wherein, my lord, 13-point roster for open. Whether the applicability of this is, my lord, again. No,
And 790.
I say it is there.
it's there, my lord. My lord, this.
Oh, yes, it is there.
It's there. 800. And if your lordship,
Here, initial recruitment,
5 posts, my lord, cadre,
5 posts.
for lordship would be UR. Initial recruitment would be UR. Second, the first replacement would be UR. Second replacement would be SC. Third would be OBC. Likewise, my lord, the 7th replacement would be OBC. Now, lordship comes to page 20 of the petition. I say, my lord, that this is there. They are applying it from the word go initially. Then, my lord, as on that, already 2 OBCs have already held the post.
But Mr. You can add on senior counsel, assisted by
Miss U Sharma, Miss U Sharma.
you, Sharma, the counsel for the petitioners. As well as Mr. DP Borat, that standing counsel for the Health and Family Welfare Department, appearing for respondent numbers
1, 2, 3, and 4, my lord.
1, 2, 3, and 4.
5
And
minutes,
Mr.
sir.
R. Leonard, standing counsel for the WPC and BC department, WPT and BC department, appearing for respondent of 5. In view of the nature of grievances raised in this present petition, like another, including notice on the prayer for interim relief, be issued returnable on when 10/4,
10-4, my lord.
10/4/2023. Requisite extra copies of the petition is served on the Learned Departmental Council in course of the day. Next one. The pendency of the writ petition shall not be of bar for the petitioners to apply for the
Well, there would be a problem, madam, because the portal, when it is open, for this post, it will be OBC. If we can't give OBC, then it will not accept, madam. So, my lord, we'll give by hand. My lord will only ask us to, we'll give by hand, let them keep it, my lord, subject to what mother father orders, my lord. The tendency, my lord, will say, give a direction. to that.
petitioners would be permitted the further considering the submission made by the land council for the petitioner that the application portal
When open, my lord.
could be opened from 1st from 1/4/2023 to 14, right?
Yes, my lord.
Till 14.
14 4/2023, and that in case the applicants in case an applicant is not an OBC candidate for the posts for which the petitioners are laying claim, or the portal will not accept the applications of the petitioners, not being an OPC. It is provided that the responding number
4, my lord.
4 would accept the physical application of the petitioners. Which will be subject to further orders may be passed on the
Returnable date.
returnable date.
Much obliged.
My lord, in item number 43, the name of SC WPT is shown. The cause list is not shown, my lord.
Item, okay. This shall reflect the name of SC, WPT and WPT and BC department. And because this by listing the matter next.
My lord, in the item number 13, only one petition. In item number 43, there are more than one, my lord.
Okay. I think only one petition.
My lord, if required, I'll give the names of the departments, my lord. No need. Names of the departments are not required, my lord. Where we'll be applying, my lord. 2 departments, Roganidhan in item number 13 and Sanskrit, Samhita and
Just write a piece of paper.
I'll
Because these names are very difficult to
Lord,
remember.
Lordship,
Item 13, For the
What?
post of
Rogan Nidhan. My lord, he'll get it.
ROGA NIDHAN.
Nidhan.
And for item 43 it is
It is, my lord, Sanskrit Samhita and Siddhanta, page 37, 7 and 11. 7 is item number 13, 11 is item number 43.
page number 37.
37, advertisement.
Of which petition?
Of, my lord, item number 43, my lord.
Of item 43. Okay.
Much obliged.
Okay. Yes.
15. 15.
Please, your lordship. Lordship, in this petitioner, lordship, in this petition, lordship, Assam Public Service Commission issued
Controlling the age.
ES lordship, containing the ES lordship. As per advertising in lordship, on 1/1/22, 38 years should not be crossed the 38 years lordship, but the petitioner has crossed only few months lordships. And this
But under the rules will not be permitted.
lordship,
The exemption, it can't go beyond the prescribed limit.
yes, lordship, as
Then-
per advertisement, yes, lordship, 38 years. But my only thing, lordship, the government earlier also, lordship, on 2016, lordship, by office memorandum has relaxed the age limit, lordship, only considering the fact that some candidate is deprived from to get into the government service, lordship. So, lordship.
Where is that circular?
Lordship, yes, lordship, I have annexed the office memorandum, lordship, on in page number 80, lordship.
80.
Yes, lordship, by notification. Office memorandum, 316, page 80, lordship. It was valid only for 2 years, lordship, but government can do, lordship. Yes. Lordship is advertisement from 2017, lordship. There's no advertisement.
You are for the post of
Post, lordship, there are many posts I have mentioned in my petition, page number, lordship, page number 8, lordship, paragraph 7, lordship. This book.
you are saying from which period to which period the post was never advertised?
Lordship, from the 2017, lordship, there is no advertisement, lordship.
Since 2017.
Since 2017, yes, lordship. I mentioned in paragraph 6, lordship, page number 7.
Where is the advertisement?
Advertisement, lordship, page number 41, 54, 59, lordship. Page number 40. And it just see, lordship. There are 3 advertisement, lordship.
Where are those?
Lordship, page number 40, page number 59.
Just a moment.
Yes, lordship.
40 then 59.
40, 48 and 59, lordship. It's 48, another advertisement, lordship. Another is 59, lordship. Otherwise, education qualification, the petitioner, lordship, eligible. Only the thing is the age criteria, lordship. Had it been advertised, this advertisement issued on 2019 or 2021, the petitioner would eligible to apply. Lordship.
But you see, the reason I'm asking you
Yes, Lordship.
these questions are, if you can come to just page 67.
67.
Oh, sorry, 68. The 68,
Yes, Lordship.
the last date of receiving the application is 30 September 2022. You are 6 months back now.
Lordship, Lordship, I have submitted the representation, and verbally I was assured, Lordship, that my representation would consider something, some positive result will
But
be.
application, the application would have closed by now.
Lordship,
The applications, you have time to,
Lordship, I have applied for the post, Lordship.
you have already applied.
Yes, Lordship. My apprehension because of the Lordship age bar, just I crossed the age 38 years, Lordship. My candidature would be cancelled, Lordship. That is my apprehension, Lordship.
I'll issue notice then.
Lordship, in the meantime, Lordship.
I have placed a judgment, Lordship, of this honorable court, division bench judgment. It says even it is worthwhile to note that this court in exercise of jurisdiction under Article 226 of Constitution of India cannot alter the eligibility criteria and age limit prescribed in the advertisement. It is the prerogative of the recruiting agency to carry out the recruitment process strictly in accordance with the rules, and hence this court cannot give direction as prayed for by the appellant.
Which para you are doing?
Last, paragraph number 9, Lordship.
No, she's not asking the court to do it. She is saying that she is applying before the authorities,
Yes, Lordship.
and they would be doing it.
It is for the government, Lordship, to condone the age. APSC cannot do it,
That is what she is asking.
Lordship.
Yes, Lordship.
She's not saying that you should do it. Where are your representations?
Representation, Lordship, in case number. Page numbers, there are many presentation, Lordship, 71, 70. Page number 71st, I have submitted representation, Lordship. Page number 70.
I wish I am the role and counsel for the petitioner. And Miss
P. Sharma, Lordship, for respondent number 5.
P. Sharma, stand for respondent number 5. Elementary education, you are there. Miss and Pugan Leonard. Stand for the elementary education department. Get in for respondent numbers. 1, 2, 3. And Mr. P. Standing counsel for SCERT. That's the respondent. The petitioner claims that she is an applicant for the for appointment in the post of lecturer
Yes, lordship.
in diets, DIETS. What is the full form, diets?
Direct lordship.
What is full stop, give full stop, D full stop, IETS. Under the establishment of respondent under the directorate of respondent number 4. It is predicted that although there were vacancies, however, the posts were never advertised between the year 2017 and that the
September, August.
advertisements for the post
Students.
were issued on 13/9/2022. Oh, sorry, we'll give three dates. Advertisement number 17 of 2022 on 26/8/2022. Advertisement number 18 of 22 on 1/9/2022. And advertisement number 20 of 2022 on 13/9/2022. Respectively. And by the time the petitioner is overaged. Stop. Referring to annexure D1, D2, and D3 respectively, I might have cited that the petitioner had submitted representation before the Secretary Government of Assam Elementary Education Department, APSC, the Secretary from APSC Assam, and to the Commissioner Elementary Education Assam for confirming her age. The same was not considered till date. First of all, it is submitted that earlier there was an office memorandum dated 3/3/2016 by which the authorities, competent authorities were empowered to relax the age limit for appointment. Accordingly, it is submitted that the respective department heads would still have power to condone the age, condone of the relax the age, upper age limit for employment. So, apprehension is expressed that unless the court passes an interim order, or the candidature may be rejected by the authorities. Next, issue notice including notice in the fair for interim relief returnable on. Give fixed date after 4 weeks. Requisite extra copies of the petition be served on the state and departmental council in course of the day. Yes, within what time you will dispose it of elementary education? These representations. Make it no, then the view qualities will be there, they will not be working. Make it before 12th.
So the interview may held any time, lordship. Yeah, it is previous years.
Scrutiny is going on, my lord.
Some time may be granted, lots of call letter they have not yet issued, Lord.
Call letter is not issued.
Not yet.
No, but the authority, you see, that is different, but they will have to dispose of the representation.
Yes, not within 15 days, they will dispose it of.
Within 15 days.
15 days.
Make it 12th, so it's before view. 3 days, 2 days is nothing. The In the meanwhile, the respondents in the elementary education department shall take note of the representations appended to this repetition is annexure D, D1, D2, and D3, and dispose of the same, preferably within 12/4/2023. Next one. List on. 28th April. 28th April. 28th April. 28th April. So it is also provided that in the event the respondent numbers the respondents in the elementary education department do not dispose of the representation of the petitioner, or the candidature of the petition shall not be rejected till the next returnable date. Yes.
She will furnish one certificate copy to the authority.
Okay. The petitioner shall produce a certificate copy of this order before the Commissioner Secretary, the Government of Assam Elementary Education Department, along with a photocopy of the writ petition, and shall also produce a certificate copy of this order before the APSC to bring the order to the notice of the said authorities. Two certificate copies.
In the meantime, if the interview held, then no should.
I'm saying, making a statement. The scrutiny is going on. They're saying with some responsibility. Because I've never been disappointed.
But the Lordship, the observation may be recorded.
No, that's what I said. It should not be rejected. What I said. And the last time protecting you, the
Yes,
committees will not be rejected. That's what I'm saying.
Obliged.
16.
Obliged.
Please, your lordship. Request your lordship to directly come to page 37 for a moment, your lordship. Annexure K.
37.
Page 37, your lordship. This is in respect of the area salaries which were due to the petitioners. This is what the respondent number 2 writes. With reference to the subject cited above, I have the honor to state that Mrs. Jyoti Singh Pathak, Associate Professor of Duliajan College, Dibrugarh, has submitted a grievance in PMO portal regarding release of a long pending personal area salaries. In this connection, it may be mentioned here that there is a budget provision of rupees 1,500 lakh under the head of account so and so during the financial year of 2022-2023, which was allotted for area proposal relating to matter of court cases, first salary, drop salary, and for retired expired cases only. Your lordship would kindly see there's a mention of the word court case. And that is the only reason, your lordship, that I have come before this court. There is no other reason. It's everything is admitted from the department. There are annexures to show that, your lordship. In fact, there was an earlier round of litigation.
Okay, your point is accepted.
Yes. Your lordship will kindly come to one more annexure, your lordship, annexure 5, annexure F at page 24. The same petitioner, at page 24. Page 24 is the recitals of the earlier writ petition, your lordship. The order starts at page 25. It is submitted by learned counsel appearing for the petitioner that during pendency of this writ petition, while notification dated 17/10/2011, issued by Director of Higher Education Assam, the petitioner has been given the benefit of senior scale of pay with effect from 31/10/1997 and selection grade scale of pay with effect from 31/10/2002. However, the petitioner has neither been paid the senior scale of pay with effect from 31/10/1997
nor she has been paid the selection grade scale of pay with effect from 31/10/2002. The petitioner shall file appropriate representation before the Commissioner and Secretary of the Government of Assam Higher Education Department through proper channel on or before 14/8/2015 with regard to her grievance of non-payment. In 2006, thereafter, Your Lordship, she attained the senior scale, the associate professorship. That scale is different. So regarding now the payment that is to be due to be released to her, it's senior scale selection grade as well as associate professor with effect from 2006. That is the only reason I've come. The petitioner has approached multiple representations before the authority, but they're not budged.
Okay.
Let's notice speak my lord at this stage.
Looking for disposal here, Your Lordship. In fact,
No, I'm not disposing in operator motion stage.
yes, sir.
And Mr. M. Sharma and counsel for the petitioner. And Mr. S. Das, line is standing us for the Higher Education Department. Waiting for respond number 1 and 2. And Accountant General. Mr. R.K. Taludar. Mr. R.K. Taludar, oh, you are there? Mr. R. Dhar, line is standing us for the Accountant General within bracket A and E on respond number 3. The petitioner claims that she had been initially appointed as a lecturer in the Digboy College against a sanctioned post. And in due course of her service, she had joined as lecturer in the Department of English in Duliajan College on 13/12/1993 with the approval of the Higher Education Department. And she received the benefit of pay protection from the Higher Education Department. And consequently, she was placed in the selection grade scale of pay on 31/10/2002. It is claimed that the petitioner is presently
An associate professor.
associate professor and posted in
Duliajan
and working in Duliajan College. The grievance of the petitioner is that
the senior scale of pay.
she was entitled to the senior
Scale of pay
with effect on 31/10/1997 and selection grade scale of pay with effect from 31/10/2002.
Yes. And thereafter, Your Lordship, she became an associate professor with a higher grade scale of pay from 2006 onwards.
And thereafter, she became an associate professor
With a higher grade.
with a higher grade of pay
Yes.
with effect from
1/1/2006.
1/1/2006.
Yes. Yes.
So it is submitted that for her entitling to area salary of senior scale of pay and selection grade scale of pay. The petitioner had approached this court earlier in point of time by filing WPC
1910.
1910/2013, which were disposed of by order dated 25/6/2015. Allowing the petitioner to file a representation within the time permitted. And the authorities were directed to pass necessary orders for release of her area salary.
Yes.
forthwith as per her due entitlement. It's probably submitted that the order of the court was produced before the Director of Higher Education.
It is reflected in the file number, your lordship, of the petitioner, which is at paragraph number 9, your lordship.
No, it's okay. I'm
Yes,
not
yes,
making those statements.
yes.
First of all, as nothing happened since then. The petitioner had lodged a complaint in the grievances portal of the PMO,
Yes.
and her complaint was registered and she was given a complaint registration number. First of all. Thereafter, by an order dated 13/5/2022, the Director of Higher Education had made a communication to the Commissioner and Secretary to the Government of Assam, referring to the complaint made in the PMO portal by the petitioner for release of a pending area salary. And the said authorities also informed that there was a budget provision for rupees 1500.00 lakh under the head of account so and so, page 37. Which was allotted for area proposal relating to matter of court case, first salary, drop salary, and for retired / expired cases only. Accordingly, the authority was also informed that the area salary in respect of the petitioner may be released if any surplus amount remains in the current year budget after releasing area to all the above mentioned cases. First of all, according to Kumar, it is submitted that the authorities in the secondary education department have not taken note of the order of this court dated 25/6/2015, passed in WBC 1910/2013, and therefore the petitioner has been compelled to approach this court again. Explanation notice. Returnable in 4 weeks. Requisite extra copies of the petition is served on the Renet's Department Council in course of the day. Next paragraph. The pendency of the petition shall not be a bar for the responding numbers 1 and 2. We take note of the hearing before referred order dated 25/6/2015, passed in WBC 1910/2013 within bracket annexure F. And consider the case of the petitioner to be covered by court case, while considering the letter number DHE of the budget ARR / 302/2017/34 dated 13/5/2022, issued by the Director of Higher Education, Kaidiraga, and addressed to the Commissioner and Secretary to the Government of Assam, Higher Education Department, within bracket Annexure K. So you are multiplying cases now. You will give only to pending court cases.
I'll bring instruction.
We have to route this through this code, honorable court.
Because this will give rise to another question. Whether this letter itself is in violative of Article 14. You're classifying people on the strength of coming to court.
Yes, my lord.
Yes.
44.
Yes, Mr. KL.
What's the petitioner is a society, they are running on B8 college. What's it may come to Annexure 2, the principal. His term was expired on 31st of August 2022. He wrote a letter to the president of the society. He may be released.
Your college is a.
What's it?
What is the status of your college?
But see, a B8 college is recognized by the NCERT, and it is affiliated to Guwahati University.
No, what is the status of your college? It's a private college.
It's a private college run by a society. Let's see what happened. Let's see, directly come to page 25, Annexure 6. The principal, after his term was about to over, he wrote a letter that he put a resignation. But interestingly, the circle officer.
The circle officer will not know jurisdiction.
Yes. Why, Lord Chief, circle officer?
He will have no jurisdiction.
My lord.
The circle officer will have no jurisdiction.
Lord Chief, interestingly, page 28. Lord Chief, please to page 28, Annexure 8. He is the secretary of the society. Hand over the accounts, passbook, checkbooks, and register of the expenditure, etc. As we are aware, that a communication by the office of the block elementary officer, Pachim Nalbari, was made by the undersigned, and it has been come to light that you have no permission to handle the account of Dr. Sarvapalli Radhakrishna Teacher Research Institute. On behalf of the project Samta Hands, you are requested to hand over the passbook, checkbook, and related register to Belset Police Station. And on next day, I was the secretary went to the police station, and the circle officer himself received the entire, and he is keeping all this checkbook, passbook, and register of the institute. What's me please to see page 29. Last part received on 11/10/2022. Aparna Sharma, CEO, Pachim Nalbari. And with the assistant of the principal, they are running the college books.
Yes.
Higher education doesn't have much role, my lord, in this case, because this is a private institute and
Okay.
B8 college. my lord.
Yes, Mrs. Burman. Where does he find this authority?
Yes. In this case, I have to take instruction, Lordship. What?
In the meanwhile, send it to the what you call the chief secretary to make an investigation.
Lordship. And we have met her as my name is a party also.
And send it to vigilance if he finds any discrepancy. Ask the chief secretary to look into it.
Commissioner and Secretary, Lordship, Education Department, Lordship.
Pardon me?
Commissioner and Secretary, Lordship, Education Department, Lordship.
No, but direct the chief secretary to look into the matter. Because this is something, why would a circle officer interfere in some society?
But Chief Secretary is not made a party, Lordship, in this case.
Which secretary?
Chief Secretary is not made a
No,
party.
no, we'll direct this. This is from the direction of the court.
Yes, Lordship.
Lordship, please to peruse Annexure 7, page 26. The message sent by the circle officer. It's a very interesting message. Lord. Page 26.
No, it's okay. We are interfering. Why should we read it?
Lord.
Yes.
Heard Mr. S. C. Kyal Learned counsel to the petitioner as well as Mrs. D. Burman and the additional senior government advocate appearing for respondent number
Respondent number 3, 4, and 5.
3, 4, and 5. And Mr. S. Das and Mr. Nichols for the
Aspirant 1 and 2.
Higher Education Department appearing for respondent number 1 and 2. Next one. The case of the petitioner is that the petitioner is a society registered under the Societies Registration Act, having registration which is valid up to 23/6/2025, and the said society is operating one B.Ed college under the name and style of Dr. Sarvapalli Radhakrishnan Teacher ' Training and Research Institute at Chamata, CHAMATA, District Nalbari, Assam. Full stop. The grievance of the petitioner is that by a order passed order communicated by the circle officer Paschim Nalbari this is by WhatsApp.
Page 26 of WhatsApp message.
By WhatsApp to TO2 whom?
To the secretary of the institute.
To the secretary of the said society, namely
Let's promote let's run. Let's promote Chandra Datta.
Pramod Chandra Datta, which is to the following effect with 26/27. So thereafter, by an order number PNC-3/2022/474, dated 7/10/2022, the circle officer, Paschim Nalbari Revenue Circle, within bracket respondent number 4, the post which is held by respondent number 6, namely Srimati Aparna Sharma, SARMAH. Has directed the headmaster who is this headmaster?
He is the secretary.
To the secretary,
Lots.
who is also the headmaster of 175 number Kulbil, KULBIL, Boys LP School, to hand over the passbooks, checkbooks, and related registers to Belsor Police Station today by 3 p.m. Today, I 7/10/2020 by 3 p.m. On 8/10/2022, the checkbooks, passbook, etc., was deposited by the secretary of the petitioner society to the Belsar police station, and from Annexure 9 to the writ petition, it appears that the respondent number 6, acting as circle officer, Paschim Nalbari, Revenue Circle, had received the same at on 11/10/2022. The petitioner society had submitted a representation to the deputy commissioner on 15/12/2022, but no action has been taken. And according to the petitioners, the petitioner society has approached this court by filing this writ petition on Article 226 of the Constitution of India. Next paragraph. You should notice the motion returnable and so and so. The requisite extra copies of the writ petition to serve on the learned additional senior government advocate and the learned standing counsel for the higher education department in course of the day. So the petitioner shall take steps for service of notice on respondent number 6 and 7 by registered post with AD. Next paragraph. Having regard to the fact that in the communication made by the respondent number 6, acting as circle officer, Paschim Nalbari Revenue Circle, there is no reference to the source of power which the said officer had derived from any acts or notifications to take over possession of the passbook checkbooks of the petitioner society. Taking note of the same, it privacy appears to the court that in this case, a high-level inquiry is required to be ordered. Accordingly, the court is inclined to issue a direction upon the Chief Secretary to the Government of Assam that on receipt of a certified copy of this order along with photocopy of this writ petition from the petitioner society, the said authority shall cause an inquiry to be made regarding the power of the circle officer, Paschim Nalbari Revenue Circle, to make any inquiry with regard to the petition affairs of the petition number 1 society and the source of power and authority to take possession of the checkbooks, passbooks, and related registers of the said society. And to bring the said inquiry into a logical conclusion. After giving an opportunity to the circle officer of being heard. Next paragraph. In the meanwhile, the court is inclined to stay the operation of the direction issued under communication bearing memo number PNC-3 of the 2022 of the 474 dated 7/10/2022. shall remain stayed.
710.
And the corresponding of 5. Shall return the passbooks, checkbooks, and the related registered to be redeposited before the Belser police station. Full stop. The release of the same to the petition shall be subject to further orders that may be passed in this repetition. Much of just one more thing. Moreover, the respondent number 4 and 6 is also restrained from taking any administrative or financial decision in respect of the petitioner number 7 society.
May I pray for copy of this order?
Okay, that a copy of this order we provided to the learned additional senior government advocate in course of the day. Much of
6 and 7.
For admission. 17 for admission.
this elementary education department.
May I please your lordship, regarding this matter, my lord, Mr. P.K. Bora is handling this case, and my lord, he is suffering some physical health issues. So my lord, kindly matter may be taken after the vacation, my lord, and
Okay.
he is not in a position to appear before this court, my lord.
Okay. Now the present call for the petitioner. Yes. And Learned Council, a standing council for the elementary education department. I submitted that this case is entrusted to Mr. P.K. Bora and standing council, who for some health issues is unable to attend the court. Mr. Honorable, the matter stands adjourned today, just after answering the vacation.
My lord, deeply honored.
What has happened to him? What has happened to him?
For last 1 week.
Suffering.
For last 1 week. He will come back in by next
Okay.
week.
I'm worried because today Mr. Roy became ill.
Yes, my lord.
Yes.
That's why. Unless. Yes,
May I please, Lordship?
yes.
Compensate amendment matter, Lordship. Petitioner father was died on 27/10/2004. And he had
Yes.
submitted one application on 13/12/2004. But his application along with other candidate was sent back to asking to resubmit the same in format.
But what is the wrong here?
Impugn order we are challenging, Lordship, as annexure 16, case 44.
But what is wrong in that?
Application we have submitted and district level committee approved. But state level committee rejected on the ground that it is time barred. Thereafter, petitioner has approached to the Honorable High Court. High Court has given one direction to the authority to examine the matter and pass a reasonable order. Then they have passed the order again dismissing my application, Lordship. That one I have challenged.
Where is the order of rejection?
Case 44, Lordship, annexure 16.
Forty-four.
44, relevant portion, case 46, para 7.
When did you apply?
I applied 13/12/2004.
2004.
13/12/2004.
Yes, Lordship. And
Okay, then what happened?
they asked me to again file, resubmit in proper format. And I filed Lordship on 27/2/2007.
Where is the where is the DLC resolution?
Resolution, Lordship, first resolution, annexure 9.
DLC?
Page.
Page 29. Page 29 starting from.
29.
Lordship, annexure 9.
This is what you see in this page 29.
Lordship.
There is asking for it. I had missed it. Here, your application was rejected
Yes,
earlier.
Lordship. DLC, I heard Lordship. I'm sorry, I heard DLC.
No, it's okay. In fact, this is the letter I wanted. Page 29. Here, this letter says that after your father died,
Lordship.
your application was considered, but due to non-availability of vacant post of LD assistant,
Lordship.
he was not approved for selection. Then
Lordship.
he again applied on 27/2/2007.
Lordship.
So this is your second application.
Lordship, this is from IS and Lordship. Again, annexure 12, but ISS, Lordship.
No, that is okay. But once your application is rejected, the end of the matter. You can't be reconsidered again and again.
No, Lordship, that was I was asked Lordship to resubmit application from
After
there, from
rejection,
the authority.
you see, after rejection, if you are asked to do it, you do it. But the court will not entertain that application. In the earlier order of this court, that is at page 36. Same thing is reflected, but then the court was somehow compassionate on you,
Yes,
and it issued a direction for reconsideration. But you see, in the second para, it is noted that your case was rejected earlier. Want to see rejected,
Lordship,
even if the authorities ask you to give it.
Lordship, Honorable High Court has directed the authority to examine the
But it
matter
can't be done.
and
The
pass on
court was
result.
compassionate enough, but we can't continue with that. We don't expect that 2004 vacancy will be here lying vacant
In 2023 now.
in 2023.
Yes, correct.
No, Mr. S. Singh,
SB Prasad.
SB Prasad. We dismiss your petition, Mr. Prasad.
Lordship, only my submission, Lordship. One annexure may be raised, Lordship. Annexure 13, ADC report, Lordship. Page 40, Lordship.
Page
40.
40.
40, yes.
This is a report of Deputy Commissioner from the Office of Deputy Commissioner. With reference to subject cited above, I have the honor to forward here with a reason particular submitted by Sujitra.
No, you see, even if the entire machinery is with you, the court can't
Actual
be,
application
the court can't be with you. You see, somebody may have found you to be eligible, but once your candidature is rejected, you show me any authority on the point that it can be reconsidered again. Repetitive consideration of the application, is it permissible in law? Merely because of compassion the court expressed on one occasion doesn't make that any right is flowing to you. Mr. S.B. Prasad, counsel for the petitioner, as well as Mrs. D. Burman, additional senior government advocate, appearing for the
Respondent number 1 and 3.
respondent number 1 and
3, Lordship.
3, as well as
I am for the
education department, respondent number 2, Mr.
4, 5.
U. Sharma, and standing counsel for education department, appearing for respondent number 2,
5 and 6.
5 and 6. And Mr. A. Sharia, and standing counsel for the finance department, appearing for respondent number 4. Next part. The case of the petitioner, to the members of the bar, I'll be rising right now after this, because I have a meeting at 4 o'clock. So after the dictation, I'll be rising. The case of the petitioner is that his father was then working as UDA in Gitarthi, GITERPHI, Girls High School, Jorhat. I died in harness of 27/10/2004. Stop. The application for compassionate appointment was forwarded to the concerned authorities, but the Deputy Secretary to the Government of Assam, by letter dated 26/7/2005, returned the said application of the petitioner to the respondent number 6 to be resubmitted in the format enclosed to the said letter. The application was resubmitted
On 15 to 2007.
on 15
To
to
2007.
2007, and the district level committee, within bracket DLC for short, bracket was had approved the name of the petitioner. However, the state level committee had rejected the application on the ground that the application was submitted late. The petitioner approached this court earlier by filing WPC 2067 of 2010, which was disposed of by order dated 19/11/2010, by directing the SLC to consider the case of the petitioner as per law and to pass a reasoned order. The SLC, in its meeting held on 18/2/2016, rejected the claim of the petitioner without considering that the petitioner had applied for compassionate appointment in due time. Next, there is no dispute that the DLC in its meeting held on 29/12/2008 recommended the name of the petitioner for appointment on compassionate ground. But it appears from Annexure 9 to the writ petition, which is a communication on the order number, page 29, number so dated 2/2010, that the application of the petitioner for compassionate appointment was rejected due to non-availability of vacant post of LD assistant. And he was not approved for selection by DLC Jorat then. Full stop. The fact that the DLC had rejected the candidature of the petitioner also finds mention in the order dated 19/11/2010, passed by the coordinate bench of this court in WBC 2067 of 2010. Nonetheless, direction was issued for reconsideration by the SLC. First, it is observed that thereafter, the SLC has again rejected the candidature of the petitioner by an order dated 18/2016. The court is of the considered opinion that once the DLC has rejected the candidature of the petitioner as reflected in communication dated 2/2010 as mentioned above and reiterated in the order of this court dated 19/11/2010, passed in WBC 2067 of 2010, there cannot be a repetitive consideration of the application for compassionate appointment. Full stop. Once the application of the concerned applicant is considered and rejected, the application is deemed to have been disposed of and would not survive for a fresh consideration, notwithstanding that the applications are made again in the appropriate format. In that view of the matter, the court does not find any merit in this writ petition of the petitioner claiming appointment on compassionate grounds. And according to the presence and dismiss, there shall be no orders to post. I'll be rising to the members of the bar. There is a meeting. Any interim orders have been extended, please tell the court master.
37, my lord, since long way it is coming in this year. It was filed in the year 2000, our petitioner was retired.
This will, you'll have to accommodate us till reopening.
Yes,
From 19th onwards, you can press me.
item 37 may be taken up after review, madam. One date may be given, madam.
The court master will give us. But for hearing matters, you'll have to accommodate until reopening after view, then we will accommodate.
Lordship, item number 35, Lordship. Order has been applied, actually, Lordship.
Applied with,
Yes, yes. He got appointment on 19/8/2021.
just note it. Just note it. Appointment made on, so your name
MS Emroy.
is M. Roy for the petitioner.
Lordship.
RB Bora,
I
standing
am
for the
14
BTC.
number 2, C is 41.
So, number 2. And
Deep
actually,
Sahari, your Lordship.
is P. Mushari, Council for Responding Bhavan. Next it is jointly submitted the bar that the order of this court has been complied with. And the petitioner has been provided with employment on
19/8/2021.
21. According to this matter stands closed as the order has been complied with.